Yes.
My lord, I mentioned one matter yesterday relating to recruitment of Constable GD in CAPF 2025. My lord directed the matter to appear today, but it is not appearing in the list. My lord directed it to appear under urgent motion.
Madam, may I permit to mention for inclusion in list, madam?
No inclusions, please. Yes.
My lord, may I be permitted to mention one urgent service matter, my lord? Pursuant to the my lord recruitment process issued by the subdivisional officer, my lord, for my lord in Anandhara project in various blocks, my lord.
No, what you want?
My lord, for upgradation, it is not appearing in the list, my lord.
Then upgradation, it has to be included first and then upgraded.
My lord, actually the written examination has been held, my lord. Petitioner's name is not there in the qualified candidates, which is, my lord, violating the rules of the recruitment process. They are going to, my lord, conduct the Viva-voce test, my lord, soon, my lord.
Yes.
So I am, my lord, requesting your lordship so that this matter can be fixed and taken up on any date subject to your lordship's convenient.
When did you file the matter?
My lord, I have filed, I have already given the notice, my lord.
When did you file the matter?
My lord, taking leave from the earlier bench, my lord, I have filed the matter, my lord. This is the, it was supposed to appear yesterday, as per the leave granted by the erstwhile bench, my lord, the Honorable Justice.
Please check up if leave is there. List it on Monday.
My
Will you be able to serve notice?
lord, I have already served notice for the
The
mention.
learned advocate?
Yes, my lord. I have already served. I will again serve, my lord,
Please do.
estimating the date, my lord. Monday,
Yes,
my lord.
please.
My lord, may I be permitted to mention one matter for withdrawal? Lord, may I be permitted to mention one matter for withdrawal, ma'am?
Withdrawal.
Withdrawal.
Give.
May I have my lord's kindly to mention one compulsory employment matter, ready matter, my lord. Exchange affidavits are exchanged, my lord. May be taken up on any.
No, sorry, please excuse.
My lord, please allow me to mention this matter for upgradation.
No upgradations,
Your
please.
lordship, kindly allow me to mention a matter for non-prosecution.
Give.
My lord, this matter is listed in the monthly list. I want.
Yes, I'll take up upgradations next week, then mention. Call the list, please.
Lord, may I have your lordship's leave to mention
For the petition in this matter, my lord.
mention a matter for correction, my lord. My lord, your lordship passed this order on 23rd of February. My lord, our submission was recorded. My lord, that we are not accepting, the School Service Commission is not accepting any certificate obtained after 21st of July. My lord,
Yes, yes.
save and accept continued DWS. My lord, that has not
Wait,
gone.
the file has gone down, both.
Lord, it has been disposed. My lord, that's why, my lord, perhaps the file has gone down.
Yesterday you mentioned.
It was mentioned on Monday. My lord.
Correction. For correction at the other one.
Grateful, my lord.
Madam.
Well, I am for the petition in this matter, my lord. If your lordship kindly come.
Madam.
Matter, my lord. If your lordship
Is
kindly
it
come.
other side?
My lord, Miss.
Has it been served?
Yes,
Is
yes.
anybody there?
My lord, they have appeared, my
Yes,
lord.
your lordship.
First time, my lord.
This is on
They
the
have
first
appeared.
time.
Tanushree Das appear in this matter, my lord.
Yes, your lordship. Ms. Tanushree Dasgupta is
Online
appearing for
process.
correspondence, your lordship. I am seeking for a short passover in this matter, your lordship. She is on legs on another court, your lordship.
What is the matter about?
Matter is, my lord, compensatory employment. He has second phase writ application here, my lord.
Who is he?
I am the petitioner in person because my
Thereafter, my lord, as per the scheme, they have invited the application, they processed my application, and my lord, finally, my lord, my case was kept pending. Now, initially, my lord, I moved writ application. If your lordships kindly see, the last order passed in the different, my lord, this writ application in earlier occasion, that is at page, my lord, 86.
Has any reasoned order been passed by the
Yes,
authority?
yes.
Where is it? Is that under challenge?
Yes, my lord, kindly,
Where is it?
page 148. There, my lord, only, my lord, ground they have taken that since they are not getting instruction from the Coal India, they are unable. But they have not said that I am not entitled. If your lordships kindly come page 148 at the last, my lord, paragraph, in view of the above, it is submitted that the undersigned has sympathetically considered the case of the petitioner, but the same can only be granted after the issuance of the necessary implementation instruction by Coal India. In this regard, as soon as the implementation instruction is issued, the employment of Sri Majhi petitioner shall be processed on priority basis and will be considered as per the company's policy.
All right. What is this implementation instruction?
My lord, actually, Coal India issued, my lord, the instructions and they are to follow. And here, my lord, the instruction is there. NCWA is the, my lord, the main, my lord, scheme formulated by them. Now, if your lordships kindly come, all these points they have taken in the earlier round of the writ application. That is at page, my lord, 140, page 86, if your lordships kindly come. Page 86, my lord, paragraph 14. This is their report they have used in the earlier round of the litigation.
Hmm.
Paragraph 14, if your lordships kindly see.
Paragraph 14 is all right.
Yes, paragraph 14 is in my favor. They have said that under the scheme I am
Yes.
entitled. Now they are saying they are not getting implementation
Let
instructions.
me hear.
My lord,
Let me hear your learned friend.
my lord. Now, my lord, kindly see, my lord, the order of this honorable court in the earlier round of litigation. What is the observation? No. Last order. Page 143, my lord. Paragraph 6. Page 144. It's my lord, relevant page. Page 144, paragraph 6 of the order, my lord. It is also not the case made out by the coal company that the petitioner has not fulfilled the terms and conditions of the NCWA, National Coal Agreement. The record simply shows that the application submitted by the petitioner is pending as under process. So thereafter, my lord, they pass this reason order. In the reason order, simply they have said that they are to take the, my lord, implementation instruction or the instruction from the Coal India Limited. In a similar matter, my lord, 2 matter was disposed of. Another order, my lord, if your lordships kindly see, the consideration order was passed, they passed the reason order and they agreed, my lord, for providing.
1 minute. Let me hear. What does this implementation instruction mean?
Lordship, it is simply not an instruction. It is an implementation instruction. It is, situation is like this, Your Lordship. NCWA, National Coal Wages Agreement, is basically signed by, is a bipartite agreement by the unions as well as by the managements. Now, the clauses are envisaged in the NCWA and in the implementation instruction, Your Lordship, that is approved, that this provisions of NCWA will be implemented. That is the, if my lord pleases, I can come up with the implementation instruction. Regarding the petitioner is of 2017. That is the NCWA 9 will be applicable because the employee was medically incapacitated in 2016 and subsequently he approached for employment in 2017. So at that point of time, Your Lordship, the 9.4 clause, which mainly categorically speaks of employment to one dependent of a worker who is permanently disabled. On that ground, the petitioner was entitled. But the only difficulty is, Your Lordship, the particular clauses, those clauses are to be signed and approved by the respective authorities. If my lord pleases, I can come with a particular implementation instruction. Because
why will the court wait for these instructions? And
Lordship,
why will the dependents suffer for not issuing this implementation instruction if the NCAWA is there?
Lordship, NCWA clauses can only be implemented subject to the approval of the implementation instructions.
Is it your case that the NCWA is not in force?
That particular clause was not in force.
Particular clause.
9.4 of
What does
NCWA.
it say?
My lord, may I, my lord?
1 minute. Do you have?
I have one. NCWA. Lordship, I'm just reading, I'm just passing it, Lordship. It mainly says NCWA 9.4. I'm referring to Chapter 9, Social Security. 9.
Yes.
In 9.4, in the case 9.4, in
Where is 9.4? This
my lord,
is
kindly refer to my
At bottom, my lord.
9.4.
I have folded the page.
Okay, employment of
one
yes.
dependent of a worker who is permanently disabled.
Yes.
Now, in this particular case, Roman 3 will be applicable. The dependent for this purpose means the wife, husband, as the case may be, unmarried daughter, son, and legally adopted son. If no such direct dependent is available for employment, brother, widowed daughter, son-in-law, they may be regarded as
Now
a
he
dependent.
is the son.
He is the son, he is entitled. In that way, as per NCWA, he is entitled. There is no denial about that. Only difficulties on our part is that until and unless these provisions of NCWA 9, that is particularly 9.4, is approved by the implementation instruction.
I do not follow your submission regarding approval. You have a law and you say it's not approved. What does it mean?
Lordship, it is, Lordship, to that effect, your Lordship, if you, my Lord permits, I can just give a short note regarding the explanation. What is the relevance of its implementation?
When will you issue the implementation
It's
instruction?
already there. Kindly see, my lord, 3.4. This is their reason order. I have, my lord, handed over to your lordships. This is their reason order. Just now I have handed over to your lordships. This is their reason order passed pursuant to the order passed by this honorable court. I have also the order for consideration. 3.4, kindly see, my lord.
Yes.
Each NCWA is for a period of 20
before
years.
arriving at the decision, it is necessary to discuss the relevant provisions and NCW. NCW is outcome of the negotiation between the management and coal company and the representative of the central trade unions that each NCWA for a period of 5 years was in operation from July 2011 to 30th June 2016. My case is also covered within this period. That pursuant to the finalization of the concerned NCWA, the implementation instructions are issued based on which the relevant provisions is given effect. So already is there.
No, it is
2016.
It is the explanation. No. Now the
see,
question is 2016. Now may I complete?
Now kindly see, my lord, the clause 9.4.0 of NCWA 9 prescribe the scheme for employment to the dependent of the concerned employee unfit, such and such. It has been quoted. Now, my lord, thereafter at the operative part of this order, you will find that they have agreed to provide the employment. This is a very recent order of February 2026, passed pursuant to the order of your lordship's court, my lord.
In respect of somebody else?
Yes, somebody else.
All right.
Kindly see, my lord, this order was passed.
Oh, it's all right.
My lord.
That is particular to a separate NCWA. Nine.
NCWA 9.
No. What my learned friend is referring to the
Yes,
separate.
it's into NCWA 9. And it was invoked from 11 to 16. We are in 26 and you say implementation instruction is not there.
Lordship, there is a difference of getting.
I do not want to know the
Lordship,
difference.
maybe permitted to submit one line, your Lordship.
Please
That
come.
is, in this particular case, it is medically incapacitated. And what my learned friend is stating is died in harness. There is a difference.
Petitioner is aggrieved by the manner in which his application seeking appointment on compassionate ground has been dealt with by the authority. Stop. The impugned order of the general manager, Shodhpur area, Eastern Coalfields Limited, dated 20th October 2025, mentions that the case of the petitioner was considered sympathetically, but employment can be granted only after issuance of necessary implementation instruction by the Coal India Limited in this regard. Stop. The The father of the petitioner was an employee of Eastern Coalfields Limited, who was declared unfit and service terminated on 29th June 2016. Stop. On that particular 29th June 29. Yes. On that day, NCWA-IX Roman 9 was in operation. Stop. The authority has neither allowed nor rejected the prayer of the petitioner, citing non-issuance of the implementation instruction. Stop. As it appears that NCWA Roman 9 was in operation till 30th June 2016, and the petitioner very much falls within the definition dependent of the employee declared unfit. Accordingly, the case of the petitioner ought to be considered in terms of NCWA IX. Stop. The not the stop. Hearing of the writ petition stands adjourned till 20th March 2026. Stop. The respondent authority shall forward a report as to why the petitioner's case has petitioner's prayer for issuance of the for grant of compassionate appointment has not been has been dealt with কি বললাম dealt with by observing that the implementation instruction has not been issued. Stop. Come back with the written instruction.
Can I record my reason order? It will,
Let us see. Reason order is already there. Again, reason order. How many reason order will come?
This reason order, my lord, passed pursuant to the order passed by the Honorable Court. That will, my lord.
Let us see. Next.
Report may kindly be directed to file by the, my lord, director personal, my lord, because he is the authority, my lord.
The general manager or the person?
Director personal is the authority, my lord.
Director.
Let anybody file the report. The court will see. Next.
Lordship, I am for the petition.
Who's for the petitioner?
Mother, I am for the petition.
Yes, please. State of West Bengal. All right.
Lordship, the matter is concerning whether the selection process of the Kolkata Police Post Constable for the panel 2030. The date of knowledge, the important thing is the date of knowledge is 19th November 2022. That certain anomalies, serious anomalies and discrepancies were there in selection process. Even a candidate whose name was there was not there in final list, the result of the written examination, he has been selected. This sort of thing has happened, my lord. Certain references are there, my lord, I am giving. But prior to that, my lord, what I want to bring to the kind attention of the Honorable Court, my lord, that proceeding is already pending before the West Bengal Administrative Tribunal. Since the tribunal is not acting, my lord, there is a order.
Is the proceeding initiated by you?
Yes, my lord.
So you move two places at the same time?
No, my lord, since the proceeding is, my lord, is not not being proceeded with in the tribunal because of the vacancy. Some matter has been ordered in the my lord,
Yes.
coordinate bench of this
Right.
court, my lord. That if the tribunal is not available, then the honorable single bench will have the determination. It will-
Yes.
jurisdiction
Yes.
take up the matter.
Right.
That's why, my lord, since the matter is not being proceeded with over there, this writ petition has been filed. If it is my lord disposed of, then not automatically that will go.
That will go. How can it be
It will-
automatic?
It will be withdrawn.
How can it be automatic?
Hello, it will be withdrawn.
It will be withdrawn. You never know what's going to happen where. You cannot take chances in this manner. What is the stage of the proceeding before the tribunal? When did you file that?
It was filed in 2023 and still it is in admission stage.
From 23
Yes,
the admission stage.
that is the point.
Then you should have approached the division bench, got an order for hearing or something. How can this be taken up if that is pending?
Mother, kindly make this observation and can leave, mother, so that I can approach the division bench on that.
No leave is necessary. No leave.
Why leave? How
Determination is
can
there.
the court give you leave to move another court? It is not that, especially the division bench. No. Please come. The petitioner is now the petitioner challenges the recruitment process initiated by the Kolkata Police Recruitment Board. Stop. Challenging now being aggrieved by the acts on the part of the authority, the petitioner approached the West Bengal State Administrative Tribunal in the year 2023 by filing OA number 315 of 2023. Stop. Submission is that the said application has not been taken up for consideration by the learned tribunal and the same is pending at the admission stage. Stop. The learned senior counsel representing the state respondents opposes the instant writ petition. Stop. It has been submitted that the petitioner ought not to move two fora at the same time on the same cause of action. Stop. Paragraph. Admittedly, the state administrative tribunal is non-functional. Stop. A litigant ought not to suffer for non-availability of a judicial forum. Stop. Next. In view of the above, hearing of the writ petition stands adjourned for the time being. Stop. It will be open for the petitioner to take appropriate steps before the learned tribunal for withdrawing the matter so that the instant writ petition can be proceeded with. Stop. Liberty to mention.
I'm grateful.
First withdraw, then come.
I'm grateful.
Lordship, Devdatta Basu is appearing for the petition and he is engaged before court number 38. I am praying for not to Lordship.
I am appearing on behalf of state. On the last occasion, leave was granted to them to file supplementary affidavit. My lord, I have not received any supplementary affidavit.
My lord, I'm appearing for WBTC. May I file my affidavit in opposition to the writ petition, my lord? My lord,
I have no staff.
my lord,
He has received supplementary affidavit. I have not received.
Supplementary you got?
Yes.
I have received.
All right. Yes.
My lady, after the direction for filing affidavit in opposition to the writ petition, my lady, the supplementary affidavit was, my lady, filed. So may
You
I?
want to file a
Yes,
supplementary opposition?
Yes, yes,
All
because
right.
there are allegations to it.
All right.
And my lady, I am yet to receive the reply of the affidavit in opposition to the writ petition.
Let him prepare it first.
Yes.
Has
my-
it been prepared?
I
You do not
am-
know.
I
Time
don't
is
know.
time has expired.
Time has expired long back.
Please come. Affidavit in opposition filed by WBTC in court today. Be taken on record. Stop. Learned advocate representing WBTC seeks leave to file a supplementary affidavit in opposition to the supplementary affidavit, which was prepared and served by the petitioner to the said respondent. Stop. Let supplementary affidavit in opposition be prepared and circulated within a period of 3 weeks, 4 weeks. I say 4 weeks. Stop. Time to file the affidavit in reply by the petitioner to the opposition prepared by the state stands extended.
My lady, it is prepared by me only, by WBTC.
Acha, by WBTC. Stands extended for a period of 4 weeks. Stop. Reply to the supplementary affidavit in opposition may be prepared and circulated within a period of 2 weeks from the date of receipt of the supplementary affidavit in opposition. Stop. What is your role in the matter?
My lord, in the last order, there is direction to file composite, my lord, affidavit in opposition. So, my lord, I require the supplementary affidavit.
Did you prepare an affidavit?
No, I have not received the supplement. I need the supplementary affidavit, what they have taken.
Achha. Let copy of the supplementary affidavit be served upon the learned advocate representing the state respondents.
My lord.
Stop. It will be open for the state respondents to file a composite affidavit in opposition dealing with the averments made by the petitioner in the writ petition and the supplementary affidavit. Stop. Liberty to mention the matter for hearing on completion of the aforesaid time period.
I am deeply obliged, my lord.
For hearing on completion of the aforesaid time period.
Didi.
My lord, this is my application, my lord. My lord.
Does anything survive 1998?
My lord, it does.
It does. All right.
But
What
there
is
are
it?
continuing wrongs, my lord. It relates to a building being erected by me, my lord. My residential house for the last 29 years. Whatever I put in there and doing it. My next door neighbor, the occupiers of the association, they were blackmailing me. They were asking for a pound of flesh. Injunction was granted in a suit filed by me. They had trespassed one of my rooms of the erstwhile structure, wherein upon contest decree was passed. Pending such decree, they were committing contempt upon contempt. Several contempt applications were filed. Well, here in 2022, what I am on is there is no urgency in the matter. Last advocate on record.
It's suit number.
Well, there is no such urgency in the matter. Last advocate on record has also expired. Thereafter, in 2022, the matter had appeared subject to correction and checking with records. It appeared before probably Justice Bhardwaj, if I'm not
Yes.
My lord, there at that point of time, my sister had expired. My lord, the lady had appeared, and she had short time to put in to check the records and do the needful. My lord, I am praying again for the same prayer. Let leave be granted to check the records and find out whether Ajalal Acharya, whose name is appearing in the list, but there is no Vakalatnama in the records, so far as I recall. My lord, so first I shall have to verify whether Vakalatnama by Ajalal Acharya has gone in.
See, last occasion this prayer was allowed, right? To inspect documents, it was in June 23. We are in 26. Why will the matter be kept pending if you say that there is nothing?
My lord,
Then there may be no urgency, but that does not mean a matter will remain pending in the list of the court.
I would tell you, Lordship. My lord, the suit is there.
Yes.
The contempt, apart from the acts of contempt which are there in the present contempt petition, there have been subsequent further acts of contempt.
Yes.
And there is an interim order. Suit is pending. The building is yet to complete. So contempt application with the interim orders has to be kept pending. Otherwise, I would be without relief.
Why? Your suit is pending. You can proceed with your suit. And if subsequent contempt has taken place, when that cannot be taken care of in this contempt.
Here, subject to correction. Again, subject to checkup of records. Subject to checkup. A lot. What I get is probably his reply has also not been there. It has to go in. That was not traceable, my lord. Then again, I shall have to prepare and file it once again. Reply is not there. If I'm not wrong. Subject. Your lordship may have the records.
Yes.
Your lordship may find out. So that is the reason I was praying. Let me be given a chance. Let me check up the records to enlighten your lordship with the current position. If Vakalatnama is not there, then Vakalatnama has to go and proceed. And thereafter, the reply has to be reconstructed and refiled. I have to assist your lordship to do the needful. And in order to assist your lordship, I must check the records once. Well, it is 3 years back. Honestly speaking, I don't recollect, honestly speaking. I candidly confess, my lord, I can't misrepresent the court.
A learned advocate representing the petitioner seeks time to revert after inspecting the records of the case. Stop. On such prayer, release the contempt on 27th of March 2026. Yes, next.
Well, keep your best.
5 is also same.
Same order.
In the department. Inspection shall be taken in the department. In same order.
Keep your best.
Madam, for the petition. Madam, the correction is at the Madam, paragraph number 3. The additional increment was initially allowed. My lord, it will be not issued initially. As well as, my lord, in view of the memo dated March 23, 2017. My lord, in my case, the state never issued any increment, my lord. Lord, may kindly have a
The notification is a general notification that is not relating to you. This first line will not be there.
my lord.
Paragraph 3.
In view of the, my lord, kindly take us up the order, my lord. I have corrected a few things, my lord. If your lordship kindly see.
You say 3, first line will not be there.
My lord, it was
The first
initially, it will
sentence,
be not.
the additional increment was initially granted থেকে এইটা এই সেন্টেন্সটা ডিলিট the first sentence, the additional increment was initially allowed ... the benefit of it shall stand deleted. আচ্ছা
May I?
After the withdrawal থেকে stopped, this will also go. Not last. After the withdrawal থেকে stopped, this will also go. ঠিক আছে? Only this much?
My lord, and on that paragraph, in view of the, my lord, memo dated 23, my lord, it was said that notification provided additional increment stood withdrawn. My lord, my contention is that in view of that memo, my lord.
All right. If you have not got the additional increment, how could it be withdrawn, will you please say? এটা হবে না, যেটা বললাম এই ফার্স্ট সেন্টেন্সটা বাদ যাবে আর এই সেকেন্ড সেন্টেন্সটা বাদ যাবে। এটাকে ফেরত দিয়ে দিন, তাহলে গন্ডগোল হয়ে যাবে।
My lord, the second way is also on the same issue, my lord.
You never got it?
My lord.
All right, same জিনিস, same thing.
I'm great.
Malata, contented candidate, re-employment, posting in distant place, representation before posting, after posting. Considering all those issues, you are also directed to consider to make fresh application for transfer. The issue, medical issue was there. Your lordship directed your lordship's court officer to observe observation regarding medical issue insert in this order. That observation has not been there in the order, my lord.
Assuming it is not there, you still get a chance. You can select whether medical, whether distance, whether any other thing. And that is the reason I kept it open for you. So it is
then it's
it is only for your benefit that I did it.
Then it's all right, madam. Only another thing, madam. Can you see this on a very set date when your lordship passed that DI issued this memo, madam, misleading the school authority. Madam, can you see the memo of the DI in respect of this?
27th of February.
Yes, madam.
Neither you had this, nor the court had the opportunity to go
See what the DI has written, madam. It's
what he has
absolutely
written.
misleading.
Not completed 5 years.
If he has not
After
got
amendment, that is not there at all, my lord. In case of
Your lordship's given liberty, it
this
is not
is
necessary.
not come.
Direct to the particular school authority. Where I am serving.
If you are aggrieved by this, then this is to be challenged. How can all these things go in over here?
Only observe the medical issue, 5 years service will not be bar. Only this, nothing else.
It cannot be done.
My lord, in the order of Supreme Court says that this
Yes,
earlier service
continuous
should be
service, everything. Even thereafter, this issue has been this.
It cannot be done in this way. Next, no order.
Very well, madam. As you have heard.
State response.
Come for the submission.
Shouldn't be done.
Higher pay scale with regard to the physical education subject, Lordship has already passed one order.
Where?
2 days before that, this was an order which was.
My lord, at first, my lord, I pray the maintainability of this writ petition.
Maintainability.
Impugn order challenge 2005. Impugn order.
No, my lord.
2024.
No, my lord.
No explanation. Not a single paragraph explaining the delay. I will file the affidavit.
Let me. My lord,
Where is the rejection order?
My lord, no, there is no rejection order. My lord, there is an order of the single bench at page 42.
Kindly cease prayer.
42, yes.
This is my case. Let me.
No, first I am
DI is
pointing the
therefore
mental
directed
ability.
to refix the salary of the petitioner by granting postgraduate scale of pay for MP at degree.
MPT. I have not filed a contempt, and my lord, this order attains finality because the state has not challenged before the division bench.
Yes.
Now, my lord, your lordship knows it's a fact that larger bench matter was pending for a long time, and ultimately, my lord, it has been held that any person before 2005, that is before coming of the Control of Expenditure Act, are entitled for getting higher pay scale. And your lordship has also passed one identical order. And my lord, division.
What you want, let me understand. The order that you referred just now, it is 20th of December 2005. That has not been implemented. You want implementation of this order? So no rejection, or are you challenging any act as such? Inaction on their part to act in accordance with this?
Just I am praying for higher pay scale. There is no.
Yes, your submission, please.
My lord, kindly see the prayer A. Withdraw, cancel, design.
What?
My lord, prayer A.
Cancel what?
The impugned memo dated such and such.
Where is that memo? See, by this order, which has been read out, the DI was directed to refix the salary of the petitioner by granting postgraduate scale of pay. It is an absolute mandatory order, right? No appeal preferred.
No.
This order stands.
Well,
Why will it not be implemented?
it will be implemented, but
When?
2005, 2024, not a single not a single.
But then the right of the petitioner are accrued in 2005 only.
My lord.
Then this should be implemented.
But that should be implemented, but there should be one paragraph at least. One paragraph. You implement that order.
I will add that paragraph, and I will also add one paragraph of heavy cost to be imposed for requiring the petitioner to approach the court all over again with a fresh writ petition.
But without any prayer.
I can see that there is delay on your part to implement
My lord,
the
where
court
is
order.
the approach, my lord, where is the approach before the DI that implement that order?
Why should it be approached separately? There is an order of the court. The state was represented.
My lord, in that case, may I file a short report? My lord,
For what?
My lord, the entire writ petition.
Please come. The petitioner prays for implementation of the direction passed by the court on 20th of December 2005 in WP 17628W of 2005. By the said order, the court directed the District Inspector of Schools, Secondary Education, Srirampur, to refix the salary of the petitioner by granting postgraduate scale of pay for his MP within bracket ED bracket close degree from the date of the improved qualification, together with other consequential relief, including arrears, within a period of 4 weeks from the date of communication of the order. The said order has not been complied with till date. Paragraph. The District Inspector of Schools, Secondary Education, Srirampur is directed to file a report as to why the order of the court has not been carried out till date.
Page 45, once.
45?
Page 45, last annexure. To whom it is communicated?
They will forward it, secretary.
At least from a school.
Went to, my lord, kindly see page 43. To the Additional District Inspector of Schools, Srirampur Subdivision. From the school, it already went. It went to the proper channel only.
আচ্ছা
আমি রাগ করছি না,
কি বললাম?
কেন করবো? দিতে তো হবেই, সে তো দিতে হবে। পয়েন্ট হ্যাজ বিন সেটেলড।
Alright.
দিতে তো হবে।
Release the matter for further consideration on 27th of March, 3 weeks time. Today is 6th. I was thinking of adding one line as to why cost will not be imposed.
But many of times, my lord, that point has been time for the petition. That point has already been added.
Yes, next. Are you going for the
What?
Lordship, I have corrected Lordship order. The prayer is the Lordship area pension from the date of death of her husband till the date of refund. Petitioner filed petition earlier and thereafter Lordship petitioner is receiving pension from the date of refund.
Paschim Mednipur?
Paschim Mednipur.
All right, disposed.
Grateful.
Is also the case of re-employment, an unintended candidate pursuant to the Supreme Court decision, re-recommendation was made. Before re-recommendation, she made prayer. There are so many schools in my residence that has not been considered. After joining one, also made prayer. Identical issue considered, your lordship, pass this order, in the matter of Shatabdi Maiti. This is your lordship. Directed the School Service Commission to consider taking note of the relevant facts.
No, but then here the case was the petitioner had two minor children.
In this case also minor children is there. Not only that, the petitioner is also suffering from severe medical problems, and all other family members have annexed all those documents also. Can you say paragraph 13 once? Paragraph 13 once.
Mother-in-law is
No, paragraph 13 once, paragraph 13.
valid ground.
Paragraph 13, I have stated details, Paragraph 13, kindly see once.
Petitioner's mother, she has a minor child. She has a mother who is dependent upon her. Petitioner's father-in-law is suffering from brain hemorrhage. Nobody to look after except the petitioner. No, not the mother-in-law, the mother. Father-in-law.
And petitioner herself is suffering from
Petitioner is also, she is seriously ill and suffering from slip disc.
Yes.
Restricted life.
Doctor advice for restricted lordship is sleep disc. Traveling is.
On 27th of February, your lordship passed this order, Malavika Nundi, relying the instruction received from the School Service Commission that after joining, School Service Commission is only considered the application for transfer. If the application, the repetition or the application could have been made prior to joining, then, my lord, the School Service Commission shall reconsider pursuant to the your.
Yes, prior joining I made, prior joining I made.
She has, my lord, made a representation. Subsequently, she joined pursuant to that appointment letter issued by the board. Now, my lord, after rendering the service for last 3 months, my lord, now she's.
Now the slip disc has happened. What can be done?
In this matter also. My lord, if your lordship kindly turns to page 55 of the writ petition.
This Shatabdi Maiti is a different matter altogether. All matters are not like this. Malavika Nondi is, at least it can be taken care of. If you want transfer, you make application and that can be considered. But then
For recommendation, I also made prayer, my lord.
maybe, but thereafter you actually joined the school. You've served there.
My lord.
And now
That's
you
the
have
admitted fact that I have
problems.
stated, my lord. That I have stated.
It's all right.
Shatabdi Maiti also, my lord, after joining, I filed this writ application, my lord. Shatabdi Maiti also after joining.
That was
But I'm living to your lordship, my lord,
not
whatever suitable for.
Shatabdi was in a different footing altogether.
My lord.
That was absolutely different.
Was there, my lord.
Yes, that was completely different.
My lord, I'm living to your lordship, my lord.
It is better you file an
My lord,
application
I'm
that
living to
can
your
be
lordship.
considered. Please come. এটা দেবেন তো 1 নম্বর শতাব্দীর 1 নম্বর তিন নম্বর লিখুন তো the petitioner submits that she is suffering from various health issues. Stop. She has a minor child to look after. Stop. Minor child to look after. Minor child who is suffering from serious ailment and under the active supervision of specialist doctors. Stop. The petitioner's mother is suffering from Parkinson disease. Check the spelling of disease. And her mother is fully dependent upon the petitioner. Stop. The petitioner's father-in-law has suffered a brain hemorrhage and is in hospital for a long period, and nobody in the family to look after them. What does your husband do?
He is in private service, my lord.
He is in private service. Acha. Four. Five লিখুন যে the petitioner sought for posting at a school which is close to her residence prior to joining the present place of posting. Stop. As there was no response from the authority and the petitioner could not risk leaving the job, she joined the school in which she was recommended. Stop. After joining, she again filed representation seeking posting in a school close to her residence. Stop. No steps have been taken by the authority till date. Stop. Did you disclose names of schools?
Yes, my lord. Page 31.
Paragraph
Three
number
schools.
6 will remain.
Page 31, what I have disclosed the name of the schools.
7 is deleted. Keep 8. Acha. Next হচ্ছে as it appears that the petitioner has already joined the recommended school and she intends to be posted in a school close to her residence. Accordingly, the instant writ petition stands disposed of with the observation that এবার মালবিকা থেকে এটা কপি করবেন। It will be open for the petitioner to make fresh application. থেকে 11 পর্যন্ত যা আছে। ঠিক আছে? Disposed.
If your lordship only one line, the school shall process and forward the application to the DI. If that.
Yes, that is there in the order sheet that he has handed over. It is already there.
That then it's all. Deeply applied.
এটা ফেরত।
Similar matter, madam.
Kindly turns to page 49.
List of your difficulties.
Page 49. The request.
Page 49.
Request.
Why the amendments? Request for no request. এটা পুরো
Enumerating hard cases.
প্রথমের দিকের প্যারাগ্রাফ গুলো থাকবে যেখানে না মালবিকারটা না আগেরটার যেটার প্রথমের দিকের প্যারাগ্রাফ গুলো 1 2 3 না 3টা বলে দিয়েছিলাম তো আচ্ছা 3এরটা লিখুন the petitioner submits that the present school where she has been posted is situated 110 kilometers away from his residence. এটা সব his হবে and it is practically impossible for him to attend school regularly. Stop. It has been submitted that the petitioner has ailing parents, has aged ailing parents to look after
Petitioner himself will also.
and look after stop. তারপর কি ছিল হ্যাঁ Here representations both times prior to joining and after?
After, only after.
Only after,
No,
not
no, no.
prior.
Before is also there. Yes. Yes. Page 22.
Did you check up?
Page 22.
All right.
Both.
Same.
Recommendation.
Say to
Prior to recommendation, he has made a prayer.
Prior to recommend.
And after recommendation, this one?
Before or after? And after. Joining or after joining?
ওটা থাকবে তারপর rest is same.
Recommendation
এটা ফেরত দিয়ে দিন।
Deeply applied. কোথায়? Affidavit of service.
এটা আগেরটার এটা আগেরটার Yes. Do you have orders with you? Please give
notice and affidavit service. The similar order passed by some correction.
এটা দিয়ে দিন তাহলে corrected orderটা দিন This is you want your pension to be released on and from the next date of retirement?
Date of retirement. Refund. Date of refund.
This is the period for which you want the interest part,
Yes,
the money.
Yes, yes. February 2009 to
Disposed. Are you there? All right.
May please, your lordship. This is my application.
You are for the? All right. Yes.
My lord, I have served all the respondents, my lord. My lord, this is the affidavit of service, my lord. And my lord, subsequent development of this case, my lord, the advertisement has been done for the final examination. That is in the my lord, in supplementary, I have already served the case. My lord, case is this, my lord. The petitioner, my lord, set for examination of West Bengal Judicial Service Preliminary Examination 2023, my lord. My lord, kindly see the advertisement, my lord, annexure P2, my lord, page 29 onwards.
Yes.
That, my lord, in the said examination 2023, my lord, conducted in 3 successive stages, my lord. One stage is, my lord, preliminary examination MCQ, multiple choice questions type, and my lord, final examination conventional type and written. And my lord, third is, my lord, personality test. My lord, vacancy is, my lord, and kindly see the tabulation form, my lord. Total vacancy, my lord, 54. My lord, I am the categorized as, my lord, general category. My lord, now, my lord, qualification has, my lord, I have completed the qualification. Age is there, my lord. And my lord, my lord, page number 34, kindly see, page number 34. There was, my lord, deduction of marks. Or there is, my lord, deduction of marks that is given, my lord, 0.25 in each question. If I attempt or this is negative, then I shall get, my lord, -25.
Negative marking, you say?
Was there?
Negative
Yes,
marking
yes.
in each question?
Yes.
All
There
right.
was, my lord, 200 marks.
Huh?
And I got, my lord, kindly see, my lord, I got, my lord, 80.
What you want to show
Yes,
from
yes, ma'am.
page 34?
Page 34, my lord, I am showing that there shall be a negative marking for each wrong answer.
Where
This
is
is top,
where
top of
is?
the.
All
top-
right. There shall be negative marking.
Yes. Now, my lord,
Hmm.
now this is, my lord, this was done, my lord, the advertisement was done, my lord, I sat for examination and examination was held, my lord. Now, my lord, kindly comes to, my lord, my booklet. See this, my lord. My lord, page 41, P3, my lord.
Yes.
My lord, in a said booklet, my lord, kindly see in the said booklet, the column 6, my lord, there will be negative marking, 0.25 marks will be deducted for each wrong answer. There was the, as per advertisement, and now, my lord, kindly run to, my lord, page number, my lord.
How are you agreeing?
Yes. I one by one. My lord, page, my lord, page number 42, my lord. Question number 17, my lord. I have challenged, my lord, the 4 questions, my lord, in the answer keys given by the commission. In the answer keys, my lord, wrong. My lord, kindly see, my lord, the question number 17, my lord. The protection and improvement of environment, including forest and wildlife of the country, is A, B, C, D option was there. They says, my lord, their answer, my lord, I have given that this is the, my lord, answer D, that is both directive principle and fundamental duty. Why, my lord? As per 48A, my lord, there was, my lord, the directive principle of the state, and my lord, 49 is, my lord, the fundamental duties. If you lordship gone through the said constitution, my lord, then it will be emphasized that this category, this question's answer is, my lord, rightly done by the client, by the petitioner, my lord, that is option D. But in below the question final answer given by the commission, will kindly see, my lord, page 65, page 65, annexure P5, my lord.
Yes.
My lord, kindly see, my lord, column, my lord, 17, my lord, left hand side, my lord. A, D, B, C. That is, my lord, in the top, my lord, the booklet series. My series is, my lord, C series. So, my lord, this is, my lord, answer is B, given by the commission. That is, my lord, B means, my lord, the fundamental duty. That is, my lord, 49 article. But in constitution, it says that this is, my lord, the 48A as well as 51A. Yes, my lord, sorry, my lord. 51 AG and, my lord, the 48A. So, my lord, I demonstrate that this is the wrong answer is given by the commission. Second thing, my lord, kindly see, my lord, next question, my lord.
What is the procedure laid down in the recruitment rules relating to filing objection if there is
Yes, but
wrong
I'm
answer?
one by one. I satisfied, my lord, the question, my lord. Next, my lord, question is 127. Kindly, my lord, 4 questions is there.
Maybe I do not want to see.
Yes. Now
Show me
procedure.
what is to be
Yes.
done.
Procedure, my lord. Yes. Procedure is this, my lord. They have, my lord, published the first, my lord, answer keys. I have stated that this is the provisional answer keys. They said, if you are aggrieved in the answer keys, you should raise objection. I raised the objection. These are the.
Show me from the recruitment rules. Where is the provision for raising objection?
My lord,
It is there in page 63, Lordship. Lordship will find a note up at the top, Lordship.
Yes, yes. Yes, my lord. Page 63, my lord, answer P4. Answer keys to be MCQ paper of the examination, details of which are provided in the following table, is hereby published for information and guidance of candidates. They are advised to compare the question answer keys with the question papers very carefully and indicate the test booklet series and serial numbers of questions regarding which they had any doubt, if any, to the notice of the commission by assessing the link at
Yes,
HTTP.
so time was between 15th of December 25 to 22nd of December 25. Did
Yes.
you raise objection?
Yes, I have raised the
Show me, please.
my lord, opposition is this, my lord. This is this one. My lord, P6, page number 67. This is, my lord, 9th January 2026. Am I right?
How is it within time? You say within the time you raised objection?
My lord, it is, my lord, says, kindly see, my lord, the commission. Yes, my lord. My lord, it is done, my lord. In a portal, I have to emphasize the what is the wrong or what is the right in the portal. That is the my lord, the portal I have submitted. But in submitted subsequently, my lord, I have in a written form, I have mailed it.
Show me that you submitted your objection
My lord,
within 15th and 22nd.
I have submitted, my lord.
Show
Can you see, my
me.
lord, the my lord, the assessing the link. I have raised the objection through the link in the website, my lord. This is not, my lord, my copy or my access to the said document. I have submitted it.
Yes, now what is your...
It is my pleadings also that I have the raised objection.
All right, now what is your grievance?
Now, my lord, subsequently, my lord, my lord, the final answer is produced. My lord, page 65. Next page, my lord. Page answer page 5, my lord. This is, my lord, final answer keys.
Page 65 you placed just now.
No. My lord, page 63 is the, my lord, answer keys. That is, my lord, provisional answer keys. I have to raise objection after that. After not considering the said objection, final answer keys has been produced by the commission. Now, my lord, there is no alteration of those four questions, my lord. 17?
Yes, then what happened?
Yes. Now, my lord, I
You
raised
were
the...
aggrieved.
Yes, I have agreed. My lord, my prayer is, my lord, very short, my lord. Then, my lord, at this stage, my lord...
How much marks did you secure?
My lord, page ta kothay ache bata dekha. Page ta kothay dekha. Yes. My lord, kindly see, my lord, page number 85. This is, my lord, OMR details is there. This was, my lord, scanned from the website. My lord, I got, my lord, total marks 80.
80.
80. Now, my lord, in the, my lord, panel, means, my lord, 497% qualified candidates, the empanel, my lord.
81.75 is the cutoff.
Yes. Yes, my lord, this is the, my lord, page number 81. There was the tabulation, my lord, category wise cutoff marks fixed for qualifying to final examination provisionally. My lord, 81.75. Now, my submission is this, my lord. If the four questions, my lord, I give the correct answer, then I shall got the, my lord, 4 marks. Addition to that, my 80 marks.
Each question has how many marks?
My lord, 1 mark. 200 marks, my lord, the preliminary examination is set, my lord. I got, my lord, 80, my lord. Only, my lord, just 1.75 is, my lord. And, my lord, negative marking I have shown to your lordship that if they assess that the 4 questions answer is wrong, then my lord, I have to, my lord, the negative marks also be given by the commission. After all, my lord, I got the 80 marks. Now my humble submission before this court, my lord. Now scheduled to be held, my lord, examination, my lord. That is, my lord, in a supplementary affidavit I have shown, my lord. That is, my lord, 23rd March of this month, my lord. 2, my lord, 2nd April 2026, my lord. Now, my lord, there is the other advertisement that the e-admit card will be uploaded in the website from the, my lord, 16th of this month.
All right.
Now today,
let me hear the commission.
yes, as you lordship.
Lordship, though I have not received the written instruction yet, but Lordship will find the model answer scripts was uploaded in the website and there was given a 7 days time to give suggestions. The answer scripts, question papers, these are all being set by the subject experts. After receiving these objections, it all had been sent to the subject experts for their views. After that, they have adjudicated and one typographical error was one typographical error has been found, and lordship will find in page 66 final answer scripts 1 mark to be awarded irrespective of attempt.
No, that is not the question over here.
Lordship, I understand, Lordship. They are asking for 4 questions. Lordship, as
What
per
are the
views
questions? What are the question? Question number 17, page
Yes,
42.
my lord. Question number 17, my lord.
Representation, Lordship.
Page 42.
Page 86, Lordship. Page 86, in the representation of the petitioner.
My lord, other 3 questions I have not shown to your lordship. My lordship.
Yes.
My lord, page 54, question
The
number
petitioner
120.
has stated 4 questions, Lordship.
Yes. Question 17, 127.
Yes,
Which
my lord, kindly
page?
see, my lord, 127. Kindly see, my lord, for a moment, my lord, page 54.
127.
Page 54. The question is, my lord, the Shruti consists of 4 Vedas, 6 Vedangas, both A and B, and D, none of the above. Now, answer is, my lord, the 4 Vedas. We know that there are 4 Vedas, my lord. Now, option given by the, answer the commission, my lord. My lord, kindly see the, they said, my lord, answer is, my lord, B, option B, 6 Vedangas. But we studied also, my lord, that.
Have you annexed any study material?
Yes, my lord. I have the book as also, my lord, I have annexed the document and I also sent the document to the commission. And my lord, page 91.
All right. Next question.
Next question, my lord. Kindly turn, my lord. Page number 57, my lord. Question number 156. Limitation Act. My lord, this is the, my lord, from the Limitation Act. Period of limitation for a suit against pawnee to recover the thing placed each 1 year, 3 year, 12 year, and 6 months. We knows very well that we are in the same pattern, my lord.
When it's the relevant provision of the act.
Yes, 3 years, my lord, in article says, my lord, 3
All right,
years.
whatever is there, you annexed.
Yes.
And next
And my lord,
question,
last one, my lord.
175.
156. Kindly see, my lord. 165.
175.
My lord, question is, my lord, if a person entrusted with money diverts it for his personal gain without intending to deceive, which section would likely be invoked? 420, 406, 420 and 406 together and none of the above. Now, question answer given, my lord, 406. It is, my lord, rightly answered done by the petitioner. Now, option given by the commission, D, none of the above. These 4, my lord, demonstratively wrong answer given by the Public Service Commission, and that for such reason, my lord, I am suffering.
All right.
Lordship, I am not aware whether during the 7 days period he
Yes, my lord, I have in the affidavit I have.
First, you check whether objection was raised or not. And second is, how was the objection considered?
Lordship. And Lordship, if these marks have to be corrected, not only in respect of the petitioner, in respect to all the candidates.
If I am suffering, all other person also
Lordship.
suffer.
Please come. The petitioner participated in the recruitment process of
West Bengal Judicial
West Bengal Judicial Service Examination, 2023 in the post of
Civil
civil
judge
judge within bracket junior division. Stop. She secured 80 marks. And tar aage, she is a general category candidate and she secured 80 marks in the written examination. Stop. the cutoff marks out of 200 is 81.75. Stop. The grievance of the petitioner is that 4 of the questions which she answered has been incorrectly assessed. Stop. The petitioner has relied upon the study materials in support of her submission that she answered the questions correctly, but the authority assessed the questions in an incorrect manner. Stop. The petitioner claims to have raised objection in the link provided by the Public Service Commission within the stipulated time period, that is between 15th of December 2025 and 22nd of December 2025. Stop. Further written representation was also submitted by the petitioner in date is January on
Milord 9th, 13th and 17th. Last Milord 17, that is an SRP 10 Milord.
9th of January 2026. Stop. Next.
Other two is Milord 13 February.
Submission is that because of the negative marking, comma, the petitioner loses. Now, the petitioner has lost marks, even though the answers were correctly given. Stop paragraph. A supplementary affidavit has been filed by the petitioner disclosing the,
copy diye to
dates
the supplementary copy diye
of the
Milord page 4 Milord.
what is this compulsory and optional subject? This is also written examination.
Yes, Milord.
Written examination.
MCQ Milord preliminary and English conventional type is written Milord. There are 11 paper Milord, 1100 and Milord
of the compulsory and dates of holding the examination in compulsory and optional subjects. Stop. It has been submitted that as the petitioner could not clear the preliminary examination, comma, she will not be eligible to participate in the compulsory in the examination for compulsory and optional subjects. Stop. Prayer has been made to direct the commission to reassess the questions being numbers 17, 127, 156 and 175 of booklet series
C.
See, Lordship, sorry to interfere, Lordship. In page number 83, Lordship, he has given different set. He has just stated that he has been given set C. And in page number 83, he has written set A, different question numbers.
No, Milord, I am demonstrating. Yes. Milord, the last and final representation is page 17, Milord, 17 February, Milord. And demonstrate all these things, Milord. Series A, B, C, D was there. Milord, I initially, Milord, from series A, Milord, but question are same, Milord.
No. Thing is, which series?
Milord, C, Milord. Milord, booklet series C, Milord, annex here, Milord, also.
85.
Yes.
Lordship,
84 and
according
85.
to
86, Milord, final
sets the
representation.
page 86 is the proper representation because
Yes.
in earlier representation he has given question numbers of set A.
Milord, in series, Milord, your Lordship knows that all the questions are, Milord, in zigzag method, Milord, A, B, C, and C, D placed, Milord. My representation, Milord, page, Milord, the 86, Milord, 17 February.
uh, learned advocate representing the Public Service Commission is directed to revert with written instruction disclosing the manner in which the objection raised by the petitioner has been considered. Stuff. As the next date of examination is scheduled on 23rd March 2026 onwards. The instant matter will be listed on 13th of March, next Friday. Service written with the records.
Lord, you'll also be directed to file instruction or report, my lord.
She'll come back with instruction.
Yes, as your lord. Grateful.
Grateful, my lord.
Check up the questions are there, the answers and the study materials have also been annexed.
Lordship.
Ten.
question.
I'm for the petition. I'm the state, my lord. My lord, highest scale of pay, my lord, covered by your lordship judgment, along with my lord. My lord, petitioner, before joining,
Have you brought any
My lord.
similar orders?
Similar order.
Let me see.
This is the order passed by your lordship. Considering the match, just number about oh, on the bill. Consider the match. Oh. After passing MPH degree, my lord, I made a representation before the authority, my lord, page 33.
Physical education?
Physical education. Before joining
Postgraduate degree?
Postgraduate degree, my lord. Before joining part 1, after recommendation of the SSC, my lord, I passed MPH part 2 examination 2005.
District Hooghly? The issue in question whether it is completed by
June 2005. Page 32.
Page 32.
Page 32, my lord, MPH part 2 examination. Page 33 representation before the authority. That will be considered, my lord.
2006 representation?
6, my lord. Thereafter, I filed a writ petition, my lord. The matter was tagged in the my lord special bench, my lord. Page, my lord, 10, my lord. Page 6, my lord, para 10.
You were a party in that Utpal Kanti Karan matter, you were there?
By your special bench, my lord.
Yes.
Covered by your special bench, my lord. WP number 12,420 of 2008, my lord. It was tagged in the special bench. That was tagged, my lord. This is the order passed. Tumibol Sinha, my lord. Page 3, my lord, special bench. This is the order, my lord. Special bench. Yes, I want it.
Pradeep. Paragraph number 7, please take down. The petitioner filed writ petition being WP number 12420 within bracket W of 2008, challenging the inaction on the part of the respondents in not granting higher scale of pay to him. Stop. One, 6, 7 বললাম তারপর হবে
এটাই মেন
8 এর পরে একটা অ্যাড হবে the writ petition filed by the petitioner was tagged along with the matter of Utpal Kanti Karan within brackets Supra. Then 9 remains. 10, 11, 13. All right, disposed.
Your Lordship was the Madhumita Banerjee also
Yes.
similar order will pass.
You have any submission?
No, ma'am. Yes.
Next.
Yes, ma'am.
I am for the state method.
I have rendered continuous service for more than 17 years. Now, not suddenly there was certain allegations against me. There was a criminal proceeding initiated. I had been enlarged on bail. I wanted to resume duties. That issue was kept pending for a period of almost 5 to 6 months. Till such time, the authorities came to allege against me that I had remained unauthorizedly absent for 38 days. And because of my absence for 38 days, public administration had suffered.
No, you were enlarged on bail. You wanted to resume duty. Then?
Then they wanted, then they alleged me of unauthorized absence for 38 days without allowing me to resume duty.
Tell you to join?
No, that was kept pending.
All right.
Prevented me from joining.
All right.
And for a absence period of 38 days, they wanted to initiate disciplinary proceedings against me. But they were free to do so. Either they could place me under suspension or allow me to continue to resume duties and not continue with the disciplinary action. Because
where were you serving?
That I was serving in CMOH.
All right.
Nondigram, that's the issue.
In the office of the BMOH?
Yes.
All right.
When they keep it pending, I filed a writ petition in January 2026. They should allow me to resume duties.
All right.
Now, on the first occasion, they did not appear. On the second day, they came up with some purported resolution of a committee, which is known as Human Resources of the Administrative Committee, which says that I am violating clause 2 of an interdepartmental memo by also working in a different security agency. Now, please come to page 75 and 77. But continuously worked for 18 years, 19 years in this establishment.
Page 75 in this, the resolution of meeting is sent here with.
They are forwarding this to me. Please come to page 77. Effective part. The effective part is the first entry. 1.1. The matter of rejoining of executive assistant Nondigram HD due to unauthorized absence was previously taken up in the 29th and 30th HRAC meeting, and the decision taken was communicated to the CMOH video order of so and so dated 5th September 2025 and video memo of 18th December 2025 respectively. On careful scrutiny of all existing documents received with reference to the above, it has been observed that the petitioner is found to be working as a full-time executive assistant at another so and so. No, this is the establishment where I am working, Nondigram, under NHM. It has been found that the petitioner is also working for MMYK Securities and Consultants Private Limited, which is an agency for supplying security service at government hospitals within the district since 2024 as per documents. As per clause 2 of order issued number so and so dated 16th October 2023 of this department, it has been clearly mentioned that the engagement will be automatically terminated if any other full-time assignment is taken up in any organization without any prior permission or intimation. Based on the above, the services of Sri so and so should be terminated with immediate effect and should not be renewed any further. Please come to the show cause note at page 69. And so that's it. At the most a recommendation at page 77. It's not a final decision. Yes.
Yes.
This is for your information that in pursuance of memo number so and so of 11th August 2025, 27th August 2025, 1st September 2025. Now these are all memos issued asking me to resume my duties. You had been repeatedly informed to join the office of the BMOH Borarangpura RH immediately, but you did not. Your absence period is since 1/8/2025 and public health services have been hampered. You have not any valid leave application in favor of absence period. The matter is intimated to the higher authority for taking necessary action and advice. Now the decision of the HR advisory committee is final regarding your joining. So I was absent for 38 days, so not to say that from 2024, I'm working in some other establishment continuously is preposterous on the face of it. And all this behind my back. No opportunity to show cause what those documents are. I have not been allowed to confront these documents.
And when were you taken in custody?
Not, I was taken 1st of August 2025 and I was enlarged on bail on 2nd September 2025.
Just 38 days.
And they say that you were working somewhere else since 2024.
Since 2024. And the allegation is because of my absence for 38 days, public health had suffered.
And you are serving as?
Executive assistant since 2008.
Executive assistant of the block. And page 77,
My lord.
1.2 ends with a paragraph, the brackets as per documents. Any documents applied to it?
Nothing. It's probably a recommendation to the employee. It has not been, it cannot be given.
Intimation. This is the matter for discussion is intimation.
Yes.
Of unauthorized absence. So no decision has been taken. The decision taken such and such is placed before the executive director for approval. So not yet, no punishment has been given to you as such.
Now,
I will kindly come to para 13, my lord.
Please come to page 79 once.
79,
Yes.
24th.
With reference to the above cited above, this is to formally communicate the resolution of the committee. No, that's page 77. In accordance with the directives received, you are hereby informed that your services as executive assistant are being terminated with immediate effect.
So it has been acted upon.
The competent authority has decided that no further renewal of your contract for the said post shall be granted. This action is taken under the provisions of clause 2 of 16.10, 16th October 2023 of by this department.
What is clause 2 of memo 16th of October?
Nothing not disclosed to us.
All right. Yes.
Kindly, I hand over the report, my lord.
What does this report say?
My lord, kindly come to date 4/10/2024. Petitioner appointed as area manager in MMYK Securities and Consultants Private Limited. A person cannot work in two places as a whole timer.
Area manager.
Did you seek for this information from this MMYK Securities? Why did MMYK hand over this to you?
But they are paired. They are paired. As per requested, he has submitted this matter.
Who requested?
Oh, that is wrong. AJ. আমরা জানি এটা ওরা ম্যানিপুলেট করা এটা আমাদের এখানে রয়েছে অরিজিনাল সেই কারণে ওকে হচ্ছে অথরাইজ করেছে
He is also signed in the tender resolution. He is also signed in the resolution book.
Resolution book.
MMYK Securities and Consultants Private Limited. Resolution.
না 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 কি বলছে?
Where from did you get this document?
কোথা থেকে পেয়েছেন?
তখন আমাদের যে গভর্নমেন্ট হসপিটালে সিকিউরিটি এজেন্সি টেন্ডার
invited.
What is the designation of
When
the
tender
person?
invited from the MMYK Securities and Consultants for labor, then they submitted this matter.
Who submitted?
এটা হচ্ছে এই যে হচ্ছে ওদের হচ্ছে ওদের ওখান থেকে অথরাইজেশন নিয়ে এসে ওরা হচ্ছে কোম্পানির পক্ষ থেকে অথরাইজেশন
Company, from the company, it was received. From the company, my
What is the designation of the person who is instructing you?
কনসালটেন্ট ন্যাশনাল হেলথ মিশন আমার স্টেট কনসালটেন্ট ল ন্যাশনাল হেলথ মিশন
State Consulting, State Consulting Law, my lord.
State consulting.
State consultant is only the cabinet rank, that is advocate general, I believe.
Actually, in this matter, I led by Mr. Molai Krishna De,
I'm told not
learned
there are
senior advocate.
advocates not who can't practice, but they are retained in the departments.
But
So
due to his father's
sudden death.
No, no,
He could
I'm
not come
not-
to court today, my lord.
All right, let him not come. But then, please come. The petitioner is aggrieved by the manner in which the authority has taken a decision to terminate his service as executive assistant with immediate effect. Stop. Is petitioner a contractual employee?
Yes.
Contractual employee, my lord.
Since 2008, he's a contractual employee.
He is serving as a contractual employee in the office of the Chief Medical Officer of Health, Nondigram Health District since 2008. The petitioner alleges that the documents relying on which the order of termination was issued were never supplied to him. Stop. No formal proceeding has been drawn up against him prior to his termination. Stop. The petitioner denies that he ever absented from work as alleged or at all. Stop. Prayer has been made to set aside the impugned order of termination. And to permit the petitioner to rejoin his post and resume service. Stop. Learned advocate representing the state respondents relies upon certain instruction forwarded by the Chief Medical Officer of Health, Nondigram Health District, signed on 5th of March 2026. Stop paragraph. As the service of the petitioner has already been terminated by the impugned order dated 24th of February 2024, accordingly 26. Accordingly, there is no scope to pass any interim order in this matter at this stage. Stop. The respondents are directed to file affidavit in opposition within a period of 4 weeks, reply, if any, within a fortnight thereafter. Stop. Liberty to mention the matter for hearing immediately on completion of the aforesaid time period. Do you have a copy of this?
Yes, my lord. Yes, my lord.
And I'll keep this on record.
Yes, yes, my lord. I have, my lord. I have. Another copy I have, my lord.
All right.
Only one humble
Instruction be
submission.
written with the records. Yes, please.
Only one humble submission. Not the post is in existence since 2008. Not I'm emboldened to make this submission because of the latest pronouncement of the Honorable Supreme Court. Kindly let them not fill up this post.
But then somebody must be allotted the job that you are doing. Otherwise, it will be difficult for them.
Some protection. Not let this not create any impediment in the event I succeed before your lordship.
The right of the petitioner to continue service in the subject post shall abide by the result of the writ petition. This service taken on record.
I'm not maybe have a copy of this note.
They will file everything by way of an affidavit, and you have a chance to revert by way of a reply. Next.
last
I am appearing on behalf of the respondent number 1 to 3.
All right.
State respondent.
Who is for the petitioner?
But I am appearing Union of India.
Petitioner?
I am led by Mr. Subroto Mukhopadhyay, my lord, in this matter.
Yes. What is the matter?
You know, before placing the document in question, may I tell you, Lordship, that I am a single mother. When my baby, age of my baby is 1.5 months, my husband, my father-in-law, my mother-in-law left. They want that it should be son. Very pathetic episode, my lord.
Yes, what is your prayer?
Prayer is this, my lord. I have been transferred from Howrah. I'm a single mother to Darjeeling. I'm placing document now one by one.
No, do not place. What is the age of your child?
And our child is now student of class 9 passed.
Promoted to class 10.
Promoted to class 10. And is your service transferable?
No.
The service is not transferable?
No.
All right, show me that it is not transferable.
Yes. Now, your lordship, may I file, my lord, affidavit of service? I have
Yes.
served all. They received a copy on 5:51 p.m. And now they release. They threw at 9. I am praying leave to file supplementary affidavit later.
She refused.
You are working in the post of?
My lord, I am working as a manager.
Manager, Social Development and Infrastructure.
Yes.
All right. Of the Howrah Municipal Corporation.
Actually, SUDA, my lord,
Yes.
State Urban Development Agency,
Yes.
a nodal agency. Now examination was held. I have passed. Now examination was conducted by the SUDA. Now they place me to Howrah municipality.
All right.
Now, your lordship, kindly see that 2000 appointment, lord, page 1, your lordship, kindly see. Sorry, my lord, page 20, annexure P1.
Previously center sponsored scheme.
Now, my lord, may I read out? In citing a reference, your proposal, memo number such and such, dated 16 September 2016, regarding the selected candidate for engagement of expert of CMMU under NLM. And later on, I will tell what is the meaning of this. For Howrah Municipal Corporation, I would like to inform you that your proposal containing 3 parties, three panels, each of 3 selected candidates against the post of Manager, Social Development and Infrastructure, Manager, Financial Inclusion and Micro
General clauses Act
Enterprises
30
and
below.
Manager, MIS and ME has been received.
Please show me your service condition. Please show me your service condition.
I made a affirmation, paragraph 9.
No service condition.
No service condition.
All right.
Because, kindly hear me, my lord, for a moment, my lord. I have been appointed in the year 2016 with this appointment letter. Nothing. And now, page, your lord, should kindly see. Page 21. Even that is issued by the municipality. First, SUDA issued letter to municipality. Then municipality.
I followed it.
Previously, it was the central sponsor scheme. Now, after central government has discontinued the scheme since 2024. Thereafter, state government is funding and state government is monitoring everything. Due to the administrative exigency, kindly come to page 23.
I have seen 23.
Yes. My lord, if I have a right to appoint somebody, I have a right to terminate and also transfer. My lord, so far the General Clauses Act, if your lordship applies the General Clauses Act.
Right to appoint, right to terminate is all right, but not right to transfer.
But transfer is the incident of service, my lord,
Maybe
because
show me that it is an incident of the service in which you appointed the petitioner. The engagement letter does not say so.
engagement has
Page
been made by
21.
the, my lord, earlier, my lord, it was sponsored by the central government. Now, my lord, central government has discontinued the.
No, all these things are not there on record. Under which provision did you transfer somebody? And that too from Howrah to Darjeeling. You transfer in some close by place which the petitioner can commute daily, then it is something
my lord,
else.
thereafter, my lord, petitioner made a representation that is also under consideration. He made the representation only on, my lord, it was made on.
Second March.
You have issued on 26.
2nd March, my lord. Therefore, I have not yet taken any.
Have you received that representation?
Yes,
Because where?
Well, 2nd March. Well, kindly see that they have issued it on second. No, it did.
Where? Because there is no proof of service of page 24 and 25.
Yes,
I do not know.
No, there is no.
Through email. Through email.
Through mail.
Where is that document to show you served through mail?
Yes, my lord.
Nothing is there.
My lord,
Nothing is there.
it is admitted fact.
Yes,
I have
though
admitted
you admit that you received this representation.
কোথায় গেল মক্কেল? May I call my client? If you
No, don't.
No. There is no representation.
No representation. Right.
No.
All right, call your client.
Yes.
Call your client. How was page 24 and 25
Yes.
served? If it is an email communication, then the email format should have been there.
My lord.
না আপনাদের মানে সুদাকে করেছে কি সুদাকে
Respect of P5, how was this letter given?
my lord.
Some government should have been here. No government at all.
Yes.
Your petitioner submitted representation. How? Mode of submission. Will you not disclose?
Yes, I have disclosed.
No, a copy of the representation is annexed to paragraph 16.
Paragraph 16 is
The mode of
absolutely vague.
and when the
Paragraph 10 onwards, your worship, can you see? I'm sorry, my lord.
I want to see how you submitted the representation. Yes, now you revert with considering page 24.
Lord.
Please come. The petitioner was engaged as manager - social development and infrastructure. Under Howrah Municipal Corporation. Under NULM for a period of 1 year from 1st of December 2016. Stop.
Lord, may I
The
declare, dear Lord,
engagement was
kindly excuse me, Lord.
temporary
Kindly see.
and subject to termination with at least 1 month's notice.
Lord, I got
Stop.
it. Mail.
The
মিথ্যা কথা বলো কেন ভাই?
স্বীকার
করে তখন আবার অন্যরকম বলছে।
ক্লায়েন্ট যখন আছেন তো
ক্লায়েন্ট মিথ্যা কথা বলবেন না প্লিজ।
আচ্ছা। The petitioner was selected for engagement by the State Urban Development Agency. Stop. By an order dated 26th February 2026, Director, State Urban Development Agency, and the State Mission Director, WBSULM, posted the petitioner in the Darjeeling municipality. Stop. The order of posting mentions that in the interest of public service and administrative exigency and for optimal utilization of human resource, comma, the assignment of the city mission managers are redistributed to the urban local body with immediate effect. Stop. The city mission managers were directed to report to their new place of posting immediately. Paragraph.
In the para 16 I have stated.
Petitioner submits that she is a single mother and her only daughter is currently studying in class 10 in Gokhel Memorial Girls School. Stop. She also has to look after her father, who is aged about 85 years and suffering from various old age ailments. Stop. The mother of the petitioner is nearly 73 years and is also suffering from various ailments. Stop. There is none apart from the petitioner to take care of her family consisting of her minor daughter and her aged parents. Stop. Paragraph. It has been submitted that it is practically impossible for the petitioner to discharge her duty in the Darjeeling municipality. Stop. Paragraph. Submission of the petitioner is that the service of the petitioner is not transferable and the authority could not have posted the petitioner to such a far off place. Stop. The petitioner prays for reconsideration of the impugned order of posting. Stop. Paragraph. Learned advocate representing Suda submits upon instruction that the project in which the petitioner was initially engaged was financed by the central government. Stop. The financing by the central government has since stopped and the state government is funding the same. Stop. It has been submitted that the reason for posting the petitioner in a different municipality is disclosed in the order of posting. Stop. Next. It has been submitted. Did you receive the representation?
Yes.
What yes?
The email 28.
Show me.
I have shown.
Where is it annexed?
My lord.
Where is it annexed?
Not it.
I have annexed.
No, not in the petition.
But representation annexed to the writ petition.
The proof of service.
Proof of service this.
No, I'm not going to see any soft copy. It should have been here in your writ petition.
My lord.
It is not there. Did you check up whether the mail was received or not?
So far, my instruction, they have not yet seen it.
They have not yet seen. What do you mean by seen?
Not received. Not received.
Was it sent with the proper mail ID? What is the name where it was sent? Achha. Though there is no proof of service of the representation of the petitioner. But learned advocate for the petitioner insists that the representation was sent through mail. Stop. Learned advocate for the authority, however, disputes receiving such email communication.
Now he has seen now.
From the petitioner. ঠিক আছে, paragraph. The
26 তারিখে
না দেবো, জজ সাহেবকে বলেছি, জজ সাহেব খেয়াল আছে।
Respondent number 2 is directed to revert with a written instruction as regards the prayer of the petitioner seeking reconsideration of her place of posting.
Yes.
Stop. The authority shall take into consideration the exigencies pointed out in the representation annexed to the writ petition to arrive at a decision in the matter. Released 13th of March, next Friday. Affidavit of service written with the records.
And leave may be granted to file a supplementary affidavit.
What?
My lord,
because she has
because
already been released.
subsequently what happened, my lord, they released me through WhatsApp.
Because she has refused to.
Just a minute, sir.
Leave is granted to the petitioner to file supplementary affidavit annexing documents which arose subsequent to the filing of the writ petition and serve a copy of the same upon the learned advocate representing the respondents
My lord.
by 10th March.
My lord, we are appearing, my lord, Union of India, my lord, whether, my lord, central government fund has been, my lord, he has stated that, my lord, stop, my lord, that
discontinue.
We have.
Take instruction.
Yes.
Take instruction. Learned advocate representing the central government shall revert with necessary instruction as regards funding of the scheme by the Union of India.
Yes.
Next.
My lord, by this time, my lord, kindly allow me, my lord, to say here, how can I leave? By this time, give some protection to me, my lord.
No, no protection can be given.
Yes.
Next.
Now, my lord, then they will take, my lord, penal measure. Your lord, kind then writ petition become infructuous. Single mother.
I'll see what can be done. Next, 13.
Yes.
I am for the petition. No, I am for the statement.
Petitioner. Yes.
I am a grade 1 nursing staff, my lord. My lord, before I submit, my lord, I am relying upon the recent judgment passed by my lord Justice Shobhata Bhattacharya, where my lord Justice, my lord, allowed writ petitions to be, my lord, filed before the single bench, but due to the fact that this administrative tribunal is not functioning, my lord. I am relying on that judgment. Lord, so my lord, I am a staff nurse, grade 1. So my lord, I have been working for the last 15 years as a staff nurse.
15 days.
15 years.
Yes.
So my lord, previously I joined as a grade 2 staff nurse. Then I was promoted in 2022 as grade 1. So my lord, presently I am posted at Raghunathpur Super Speciality Hospital. Though my lord, substantial post is at, my lord, at
somewhere else.
Somewhere else.
Yes.
I am posted here officiating as a sister tutor here. So, my lord, the promotion, the transfer policy, my lord, requires that after being at a position, at a post for 3 years, my lord, we can apply for transfer. So, my lord, I applied for the transfer. My lord, the transfer, there is a transfer portal, my lord, where we need to, my lord, submit our online application, and we have been given 3 preferences, 3 choice preferences. So, my lord, I gave my lord 3 choices. First was the, my lord, the NTS or the
Where is the your posting right now?
My lord, my posting right now is at, my lord, Raghunathpur Super Speciality Hospital.
Page number?
My lord, 31.
31.
This is a detailment order.
Yes.
But the substantial.
Where is your name? Serial number?
57, my lord. 32,
57.
57.
32.
Serial number
Madhumita
57.
Ghoshal.
My lord. I'm thankful.
Present place of posting is Devan Mahato, Purulia, and you have been
shifted to the, my lord,
Raghunathpur.
Yes. Super Speciality Hospital for officiating. So, my lord, I applied for.
This was in 22. You applied for transfer.
Yes.
Yes. Then what happened?
Well, this was promotion. This was not transfer. This was promotion.
All right, promotion.
So thereafter, my lord, I opted for this transfer.
All right.
By submitting my transfer application, your lordship will find at page number, my lord, 33.
What is page 38? Where have you been posted now?
Onda.
My lord,
Bakura. Onda.
All right.
Bakura. Bakura. Again in Bakura district. Same district, my lord.
Same district. Purulia, Bankura, same district.
Now his posting is, my lord, Lordship, can you come to my lord?
Onda, my lord.
Onda is Bakura, my lord.
No, she was in Raghunathpur. I can see Purulia, page 32.
Purulia.
Then from Purulia, when did she go to Bankura?
So, my lord, I opted for Bankura.
You opted for Bankura.
For
All
Bankura
right.
because I reside at Bankura.
All right.
But my lord, I
Then-
opted for the nursing training school, Bankura Sammiloni Hospital, or the Bankura Sammiloni Hospital itself, or my lord, a leprosy hospital in Bankura. My lord, these are the three options. Now, my lord, this transfer order was issued. I have been transferred to Onda.
Yes.
But my lord, I find
you are aggrieved.
I am aggrieved by this.
In the same district, even then you are aggrieved.
And the Bakura Sammiloni Hospital and the Onda is half an hour's distance, my lord. Only half an hour's distance.
37 kilometers far away.
Only half an hour's
Yes.
distance.
My lord, kindly appreciate only one thing, my lord. I would have not approached this court unless, my lord, there is some kind of discrepancy, my lord, that other person's, my lord, preference has been considered, but mine was not. My lord, a person who is junior to me, my lord, the last
Is not
person,
the case, my lord.
Papia
Junior is
Laik,
posting,
the
my lord.
last person in the list, Papia Laik, my lord, she is junior to me and she had applied much later to me. My lord, so this
But
list
the
of
ground matters.
my lord, my preference should have been
No
considered.
preference. Even while considering preference, you have to see whether it is self-medical ground, the family medical ground, distance ground,
I have also
single
given,
mother
I have
special
also
ground.
given my medical condition as a ground, my lord, in my online application.
Where is your application? Let me see.
My lord, 33.
Yes, reason for transfer is self-illness.
So, my lord, the ground for not
Where you
considering
checked up,
mine,
where you checked up by the doctors to ascertain your illness.
there was no scope for, my lord, submission of any, my lord, medical document in this.
So somebody says self-illness and the authority will believe.
My lord, then the others might have cited the same thing
I do
because
not
there was
know.
no option to, my lord, upload any medical document. This is
May
the
not
self
be
declaration, my lord, that is need to be uploaded.
self-declaration, but then thereafter.
My lord, there is no, my lord, process of, my lord, examining each and every application. My lord, this is the entire system is online. So, my lord, if somebody else have, my lord, there is no question of uploading anything else other than this self-declaration.
All right.
My lord, there is vacancy which is, my lord, transferring from this transfer order itself. That, my lord, several others, my lord, I have indicated the serial numbers who have been transferred to Bakura Sammiloni.
Is there a request?
No.
My lord, there is a request or at page, my lord, 50.
50 wala 28 mala they
Yes,
made a
due to-
request.
due to, my lord,
By second they have filed this
yes, due to
petition.
paucity of time, my
All
lord,
right, take a decision on the request.
my lord.
Very well, my lord.
The petitioner prays for consideration of.
In accordance with law, my lord.
Certainly. Prays for consideration of the order of transfer. Issued on 27th of February 2026. Stop. The petitioner is serving the petitioner now prior to the order of transfer being issued, comma, the petitioner was serving at NTS Deben Mahato Government Medical Hospital, Medical College and Hospital. No.
My lord, officiating at Raghunathpur. Yes, my lord, the posting was at Deben Mahato,
Oh,
but I was officiating
and
at Raghunathpur.
officiating at NTS Raghunathpur Super Speciality Hospital, Purulia. Stop. She has been transferred. Now, she applied for transferred on self-illness ground. In the district of Bankura, and she disclosed her preferred choice of posting. Stop. In the impugned order of transfer, she has been, not in the, by the, she has been transferred in the district of Bankura, but however, in a different hospital, which is not as per the choice of the petitioner. Stop. Paragraph, she alleges that employees junior to her applied for transfer and has been allotted the hospital preferred by the petitioner, ignoring her seniority and eligibility. Stop. A request has been made by the petitioner to the Joint Director of Health Services within bracket nursing on 28th of February 2026 to reconsider her place of posting. The same is pending consideration. Stop. Paragraph. Learned advocate representing the state respondents submits that the petitioner has been posted to the district of her choice. Stop. The place where the petitioner preferred for being posted is not more than 50 kilometers away from the place where she has been posted. Stop. Paragraph. The service of the petitioner is transferable and the employer is the best authority to decide as to where to post the employee for getting the best service. Stop. In the instant case, the petitioner has been posted in Bankura, but in a hospital which she claims is not as per her choice. Stop. As a representation seeking reconsideration of her place of posting is pending consideration at the end of the authority, comma, the instant writ petition stands disposed of by directing the respondent number 3, the to consider and dispose of the petitioner's prayer strictly in accordance with law at the earliest, but positively within a period of 4 weeks from the date of communication of this order. The fate of the petitioner's representation shall be made known to her. Writ petition disposed.
The right to join at Baku at her preferred posting
Yes.
shall abide by the result of this
The-
recognition, my lord, only
yes. The
otherwise, my lord, if all the posts are my lord, filled up as per this transfer order, my lord, they will say that we cannot.
no, I didn't get
join
it.
on the
1 minute. Oh, what was your submission?
My lord, if the posts are filled up
Yes.
as per the transfer order, my
Right.
lord, they will say that there is no more vacancy.
Right.
So you cannot be accommodated.
Yes.
So my lord,
I understand, but what can the interim order be and what type of protection can be given to you?
my lord, at least some
But
kind
only protection that you will join as per the impugned order, otherwise you'll be in unauthorized absence.
that is a separate issue. But my lord, if
If you want to stay at home, stay at home.
my lord, if
The court is not
consideration
saying.
goes in my favor,
Then it's all right.
then my lord, they will say that no, there is no more vacancy.
Let us see. This is too early to say. Next.
My lord, affidavit of service.
Complaints. 21.
Yes, my lord. Pursuant to the order of this honorable court, my lord, the DI ascertained a vacancy and asked the petitioner to exercise her option. My lord, he went to the office of the exercised option. That was in the year 2024. Last
Motamgram High School.
yes, my lord. Your lordship directed the respondents to take instruction whether the vacancy is still existing or not.
Oh.
Vacancy is still existing.
As per the my report, also 2024, lordship.
Well, thereafter, no.
Yes,
thereafter,
Lordship, I don't
no.
know the school service commission, Lordship, vacancy, is that filled up or not, I don't.
No, on the
I will know whether the vacancy is still there or not.
The only one
And
vacancy.
whether this vacancy has been included in the SLST, that is also.
I am saying that.
My lord, on the last occasion, I had submitted that we have not received any communications from the DI regarding this candidate or a
Availability.
vacancy.
Hmm.
The vacancy which was shown on the last day, I had asked my learned friend to give me a copy so that I could follow it up. That I have received only today. So I could
What
not.
does it say?
So I could not check whether this school is still available or whether it has been advertised.
So you want to come back again?
So that is the
20th of February was the last day
Yes.
when the order was passed. Learned advocate representing the state respondents and the School Service Commission seeks time to revert with up-to-date instruction as to whether vacancy in the post of history in the normal section of Modhamgram High School within bracket HS is still available or not. How soon? 17th of March.
My lord.
Today is 16th. 6th.
Yes.
Well,
Released 17th. Next.
Lordship, we are the Union of India.
Your Lordship, learned advocate for petitioner Ujjwala is on legs before court one. Kindly grant a not today.
What is the matter about?
Lordship, already report has been filed. Or report, they have also filed the inspection report.
What is the matter about?
Lordship, they have they have submitted the false certificate
Yes.
for the job. And after that, he was terminated. He was also imprisonment was given to them, to him, Lordship. And after that, they have several written filed in the Chandigarh. After they are gone for the criminal revision. After that, again, they have come for the third writ, Lordship. We have already filed a report.
Only not today. But next day, no adjournment will be granted, I tell you. Not today. Next.
Grateful.
Lordship, only 9-10 can be about.
9-10.
Because
next day, if it is called on, you make your prayer. I'll just do one thing. Accommodation has been sought for on behalf of the learned advocate representing the petitioner. Stop. Released on 13th of March,
Lordship,
Friday.
I'm grateful to you.
Grateful.
Next.
Petition.
22 to hoye gelo, 23.
23. After petition.
Yeah.
State.
State.
Procedural.
I am for the state, my lord.
I am for respondent number 6, my lord.
Animesh Babu, is this matter? On behalf of the petitioner at the time of call?
Sorry, madam, for the petition.
No, sir, you are not for the petitioner. This is not your matter.
So I'm so sorry. I missed, madam.
Do you know the learned advocate who's standing just behind you?
Yes, madam. Pardon.
Oh, he's a junior.
Yes, madam.
Then he must be knowing the next matter is going on.
I'm so sorry, madam. I just missed this, madam.
It is not item 22, it's 23. Acha. Next. Ki bolam? None appears. Stop. The writ petition was mentioned for inclusion in the list, citing urgency. Stop. Forensics of Justice released the matter on 13th of March.
No notice was served upon us for mentioning.
No notice. All right. Next Friday, you please remain present. Next.
Please, Your
Well,
Lordship.
I am for the respondent, my lord. This is a matter regarding, my lord, affidavit in opposition and my reply has already complete, my lord.
This has come at
Your
my
lordship kindly take it up any date, my lord, for fix up hearing, my lord.
May I just say, my lord, this has come at my instance, but my lord, that my lord, at the time of mentioning, my lord, I did not. It's my mistake that, my lord, that this has been a hearing matter. This and the next one as well.
Yes, my lord. Yes,
My lord,
that is the hearing.
this, my lord, pertains to the dismissal of our BSF employee, my lord, on the ground that he had, my lord, supported or he was in connivance with the medical, my lord, personnel of BSF at the time of recruitment of the detailed medical examinations which are being taken. So he, at the instance of one Dr. Lokeshwar, my lord, was part in a racket where the medical examination was wrongly done or fraudulently done with respect to one individual in lieu of money. That was the allegation against this the other persons along with this incumbent, before your lordship. So the fact of the other, my lord, merits of the matter I'll not go into. I have, my lord, several grounds on them, but on the procedural irregularity which, my lord, I have challenged before this honorable court, that this individual has been dismissed from service, my lord, by, my lord, taking into play, my lord, 22 of the BSF rules, which, my lord, specifically provides two situations where the exercise of the regular disciplinary proceeding against the incumbent is not possible, and second, that retention of this individual in the force is completely not possible. So these subjective satisfactions of these situations has to be proved, and then this individual can be outright dismissed from the service without any disciplinary proceeding. So this has been done in this particular petitioner's case, my lord. Interestingly, the other doctors who are, my lord, there in the same crime, against them, my lord, the full-fledged disciplinary proceeding has happened. But this individual, my lord, he was straightway dismissed from the service by implying Rule 22 of the BSF rules. So, my lord, my challenge before this honorable court only on two grounds. One, there was a preliminary inquiry, which they call it, my lord, summary court of inquiry, a COI proceeding. And my, this is a preliminary inquiry. And this particular report of the preliminary inquiry was never handed over to the petitioner before issuance of the show cause or before issuance of the punishment. This is one ground. And the last ground, my lord, that in the order of dismissal, that this particular subjective satisfaction that this the disciplinary proceeding against this particular individual is not practicable or practicable to be held. This observation is not at all there. Reason is not at all there. So, my lord,
Your lordship kindly take it up any date, my lord, for fix up a hearing, my lord. I will be satisfied against this. Their petitioner is arguing this matter, my lord.
Why? What is the difficulty if it is taken up today?
Today is, my lord, this is under all on a sudden it is listed, my lord, under hearing motion, my lord. Without,
All
my
right.
lord.
If you want time to come prepared, it's all right.
Yes, my lord.
Learned advocate representing the Union of India seeks time to come prepared for hearing. Step 13th of March, next Friday.
Deeply lovely.
Please, Your Lordship.
My lord, learned advocate Mr. Ashim Kumar Ganguly is not well. Kindly fix it Monday.
Who is he appearing for?
For the state, my lord.
State?
Stating and party now.
I'm
Lord, I'm for the petitioner. Lord, the same, my lord, here, my lord, the challenge before this honorable court was the lowering of the mark in the APARs. So, my lord, APAR is the annual performance assessment report. So here, my lord, the individual before your lordship is an, my lord, employee. And my lord, he works as an office clerk. So what happens before the authority, my lord, before the BSF authority? So my lord, he initiate, my lord, for past 23 years of his service, my lord, he has been receiving outstanding APARs. But what happened on the particular year, which starts from 22 to 23, my lord, his APAR was downgraded to good from very good. So against that, my lord, he preferred representation and said that there is no basis of downgrading this particular APAR. So while challenging that, my lord, the authority rejected his prayer by saying that no, you were rightly downgraded with the APAR mark. Challenging that, my lord, he has come before this honorable court. So my lord, only my ground before this honorable court for challenge was two, that this particular person, while my lord working for the past these several years, my lord has got 24 accolades and stars from the BSF authorities. Be that as it may, my lord, if I just request your lordship to see the APAR once, I'll just take your lordship 2 pages and thereafter my submission will be over. My page number from page number 24, my lord, the APAR of this individual, your lordship will see from page number 24.
Yes.
So page number 24 at the top, your lordship will see that the period, which is 1st of April 2022 to 31st of March 2023.
Yes.
So then, my lord, kindly turns over the next page.
What is the remark over here?
Yes. So I just take your lordship to that. If your lordship kindly turns over to the next page, 25.
Yes.
So there your lordship will see here the procedure is that the immediate senior under which this particular incumbent works, they will be given the appropriate mark. They are said to be the reporting officer. Then there is another officer who is above the reporting officer. He is said to be the reviewing officer. So there your lordship will see the column. All this column are 6.5, 6.3, 6.5, 6.2, and the reviewing authorities column lordship will see 6, 6, 6, 6. And on the next page, same. 6.2, all of them have been made to 5, 5, 4.5, and 5. My lord, then on the next page, same. Then, my lord, page number 27, your lordship has seen there the reviewing of reporting officer under whom, my lord, I have been working. There, my lord, there are 3 officers. Lordship has seen at the bottom of page number 27. So all of them, my lord, has written my integrities are beyond doubt. They are the reporting officers column. Then, my lord, turns over to the next page, 28. So it says that if I could place, my lord, the handwriting is a sincere and hardworking head constable. He is ministerial. He is performing his duties in OPS branch 1.
I grade him as very good.
So sorry. I grade him as a very good. On the next page, lordship sees the mark of the reviewing officer, which is under challenge before your lordship, page number 29. So it says that I generally do not agree. Individual has been asked explanation at many occasions. He has been advised twice by office commandant of such and such BSF. He requires to improve upon his casual attitude, and he requires to improve such and such and maintain
relationship with seniors and subordinates.
Yes. So thereafter, my lord, his mark has been downgraded to 5.46.
Right. It is for the same period, isn't it?
Same period, my lord. He is the reviewing officer. He straightway, without giving any further explanation why he has put this, he has downgraded this. So, my lord, thereafter, your lordship will see that I have made the application before the authority that my representation is annexed, my lord, which is in Hindi. I have annexed the translated copy as well. Lordship will see that page number 73 would be the order against which, my lord, I have come before this honorable court.
Yes.
So there your lordship will see that the order says...
See, it is absolutely subjective satisfaction of the reporting officer and the reviewing officer. Where is the scope of the writ court to enter into all these things?
If I could just point out your lordship, the bias.
Yes.
My lord, if I just could take your lordship to the bias. because this bias, if or this procedural irregularity, if I could point out your lordship, that in that event lordship could interfere. So my lord, what I was just saying, that before the rule says, which my lord I have stated in my reply, though my lord I am not having the copy of the book today, but the rule says that before imposition of this kind of my lord, downgrading of the APAR, one has to be given with the 3 advisories. So my lord, he has been given with 3 advisories. Lordship kindly sees the advisories. The dates of advisories will be extremely important. My lord, the dates of advisories would be that I have stated in my representation, which your lordship will see from page number 49, 50. So there, because it is a translated copy, my lord, the dates your lordship will see page number 50. My lord, A, dated 7th of January 2023. B, thereafter, my lord, sees 8th of January 2023. And the next one is the next page. The other is 9th of January 2023. So this reason for my lord providing the advisory, so that I can, my lord, improve on my own qualities. Lordship will see 3 advisories have been given on 7th, 8th and 9th January. So thereafter your lordship will also see what are the content in the advisories are completely different in 3 other matters. So one says that I did not put my signature in the attendance roll. The second one says that I did not my lord, reported to the authority that someone has come with a different identity card which he ought not have come. And third is I did not perform so many other, I am casual in doing other things. So these particular advisories, my lord, are one after another, which completely does not give me, my lord, the scope so that I can improve myself, which is the requirement of the advisories.
In the next period for which you will be assessed, you can improve yourself.
My lord, then in that event, for the purpose of my lord, putting an adverse remark in the APA, the advisories are required. So my lord, I did not given with this chance of, my lord, making myself better. And the issuance of this advisories on 7th, 8th and 9th itself shows that it is only for the purpose of face saving, my lord. So I am today, my lord, not equipped with the order or the rule of the BSF, which says the advisories are required for the purpose of
All right.
giving
Affidavit and opposition filed on behalf of the respondents in court today be written with the records. Is your reply and the reply there too. Opposition and the reply there too. Released 13th.
Grateful. Yes. Yes. New matter.
A
Completed.
new matter. Then we'll take up on the next day.
My lord, item number 30. My lord, it's transfer matter under pathetic situation that the daughter of the petitioner is 4-year-old and she can't able to stand, neither she able to sit properly. My lord, may kindly take up the matter at any convenient time, my lord.
Who is your other side?
My lord, if my lord kindly permit me, then I can serve.
If you can bring your other side at 2 o'clock, I'll take it up.
As your lordship.
Bring your other side.
My lord.
Item 30.
Item 30.
You are for the petitioner? লিস্টের নিচে 10 তারিখ লিখে দেবেন তো লিস্টের নিচে 10 তারিখ লিখে দেবেন আইটেম 31
indulgence to mention a very, very urgent matter.
But why now?
My lord, I had a different notion that it would come automatically, but they are telling that until and unless the lordship grants it.
Automatically means?
It was filed, but it didn't come in the list today. It was scheduled to come in the list.
It will come in the list. New filing? It will come in the list. Please wait. It will come. Please wait. Yes. You got your other side?
Yes, my lord. Other side is present. I am for the petition. Yes. Affidavit service, my lord. But the petitioner is the Group D staff.
Item 30.
My lord.
Yes.
30. It's a Group D staff posted in the posted at Purulia under Jhalda video. My lord, the appointment letter is annexed here with my lord, page 11. And in the year of 2023, he got a baby, little girl child, my lord. And from her birth, she is suffering from various neurological problems. One is a dystonia. That is dystonia. May I submit the?
No, don't say. She's suffering from various ailments.
Yes.
Now what do you want?
And I want transfer for that. And I had made transfer from Purulia to Paschim Mednipur, where my residence is there, in Paschim Mednipur. I had made several representations. My lord, kindly come to page 29, the relevant, where I have made a representation.
But is there a prescribed format in which you are to apply if you want transfer? There is a transfer portal, isn't it?
Well, Uchosri, I think so. As far as
No,
knowledge goes.
Uchosri is for education.
Education, yes.
There are other transfer portals.
But after my application, the government has responded. Kindly have a look at page 29, my lord.
29.
Government has responded, my lord.
Yes. This is in 2024.
Yes.
Proposal for inter-district transfer. No objection.
I am directed to request.
Certain documents you are supposed to submit. Isn't it?
It's direction upon the DM.
Yes.
Give no objection.
Right.
But yet now no objection has not been granted, my lord.
Because they have objection. That is the reason no objection has not been granted.
Either there is no objection or there is objection. They are not says that there is any objection or there is no objection. I just want on that ground, my lord, because the girl child is suffering a lot and a regular physiotherapy is required. And being a father, I can do that.
Have you seen that? You will lose your seniority and you have to join in the bottoms.
Yes, my lord. I had consulted with my client, my lord. But for the sake of the baby,
past service will be counted for leave and pensionary, but MCA's benefit you will not get.
I have to go abide by this, because either there is no other alternative for me to take care of my baby, my lord.
Any response?
Let it be considered by the district magistrate for issuance of this objection. Considering the girl child's predicament.
Listen, page 29, there is already a direction from the Joint Secretary, Land and Land Reforms to the DM.
But DM has
not
yet
why?
Communication that I have not yet received any instruction.
You should have taken instructions. Please come. The petitioner is serving as a Group D staff in the Purulia Collectorate. Stop. He applied for transfer. Stop. The Joint Secretary to the Government of West Bengal, Land and Land Reforms, and R.R. and R Department. Forwarded a communicating memo dated 30th October 2024 to the DM and Collector Purulia. In respect of the proposal for inter-district transfer of the petitioner. Stop. There is no response to the said memo till date. Stop. The district magistrate was requested to offer his views as well as consent on the proposal for inter-district transfer. Stop. The petitioner is aggrieved by the same. Stop. Next. Learned advocate representing the state respondents is not ready with any instruction. Stop paragraph. In view of the above, the instant writ petition stands disposed of by directing the DM and collector, Purulia, to take steps in response to the communicating letter dated 30th October 2024. At the earliest, but positively within a period of 8 weeks from the date of communication of this order. Stop. The fate of the petitioner's application seeking transfer shall be made known to him. Stop. Learned advocate for the petitioner is directed to forward a copy of the communicating memo dated 30th October 2024, along with all supporting documents to the DM and collector Purulia for taking steps in response to the above direction. Exposed. Service taken on record.
Well, let me kindly note that considering the medical reports of the...
I have given you leave to forward all documents. So he will offer his views upon consideration of all. All right.
Deeply.
Yes.
I was dealing with the judgments, my lord, which were cited by the petitioners, my lord. I have stopped at 2021 volume 5 SCC 524. Now, my lord, there are 4 more judgments which has been cited. Now, my lord, your lordship will kindly next take 1988 volume 1 SCC 692.
দেখুন তো এতে কোনো জাজমেন্ট আছে? Judgment. না না। 1988 you said?
Yes, 1988 volume 1 SCC 692. The petitioner has relied on paragraph 5. So I'm carrying a copy, my lord.
I just check if it is here, otherwise. Yes, yes.
Madhav Rao, Jivaji Sindhya.
Yes, yes.
Versus Sambhaji Rao, so and so.
Yes.
Now, my lord, this has been shown on the point that quashing at the initial stage if no offense is made out. Now, my lord, your lordship, my lord, in this matter, kindly takes paragraph 8 first.
All right.
Kindly takes paragraph 8 bottom. Thereafter, I'll come back to paragraph 2 and 4.
All
But kindly takes 4 lines above paragraph 9. But here for the appellant, Dr. L.M. Singhvi was appearing. Kindly sees his submission there. In course of hearing of the appeals, Dr. Singhvi made it clear that Madhavi does not claim any interest in the tenancy. In the setting of the matter, we are inclined to hold that the criminal case should be continued.
Should not
be continued. Therefore, my lord, the counsel for the appellant said that the dispute was with regard to tenancy. I'll show your lordship. He said that my client does not have anything to do with the tenancy. We are not laying any claim on the tenancy. Therefore, the Supreme Court said that then there is no need for the criminal case. Kindly now seize the facts. In view of that submission, kindly seize the fact. Kindly, my lord, takes paragraph 2 continuing portion at page 694. Towards the middle, 5th line from the top. On the allegation.
on the allegation that the two officers of the trust in conspiracy with the trustee Madhav Rao and his wife Madhavi had created documents showing tenancy in respect of that flat in favor of Madhavi, a complaint was filed by trustee Angre in the court of the Metropolitan Magistrate 28th Court, Esplanade, Bombay on July 27, 1983. So this was the crux of the complaint, that they have forged some documents to take over the tenancy. And that tenancy was given up in the submissions. That is why they can you take the paragraph 4 now, paragraph 4. 5 lines from the top, sentence starting with, the flat had been tenanted. The flat had been tenanted at a particular rent when the tenant vacated and a new tenant had been inducted. It being the common case that the flat was intended for tenancy, Madhavi wanted to be the tenant, and at the rate of rent which the outgoing tenant was paying, a new tenancy was created. Under the law applicable to tenancies in Bombay, a higher rent is not chargeable, and as such, no higher amount of rent could be claimed by the trust in regard to the flat. The wife of the trustee is an independent person having her own income, and the tenancy in favor of Madhavi cannot be considered to be creating an interest in favor of the trustee. Dr. Singhvi further relied upon a lawyer's notice issued on behalf of the trust calling upon Madhavi to surrender the tenancy in favor of the trust, failing which action was threatened. Madhavi volunteered to surrender the tenancy, and thus there was really no justification, according to Dr. Singhvi, for initiating a criminal proceedings. The entire dispute was a civil dispute pertaining to a tenancy, out of which a criminal proceeding was initiated. When it reached the apex court, the counsel said that my client gives up any interest in the tenancy, and the criminal proceeding was dropped. Therefore, it is quite distant from the facts which are before your lordship. Now, this judgment, Madhav Rao Jivaji Scindia, was later explained in a decision in 2011, volume 12, SCC 437. Volume 12, SCC 437. Mullah will kindly take paragraph 19 to 22. 19 is quotation of paragraph 7 there, I'm not reading it. Then 20. This court, while considering the judgment in Madhav Rao Jivaji Scindia, had consistently observed that where matters are also of civil nature, that is, kindly marks, my lord, matrimonial, family disputes, etc., the court may consider special facts, special features, and quash the criminal proceedings to encourage genuine settlement of disputes between the parties. The said judgment in Madhav Rao case was reconsidered and explained by this court in State of Bihar versus P.P. Sharma, which reads as under. I'm skipping over the quotation, 1022. Thus, the judgment in Madhav Rao Jivaji does not lay down a law of universal application. Even as per law laid down therein, the court cannot examine the facts or evidence, etc., in every case to find out as to whether there is sufficient material on the basis of which the case which end in conviction. The ratio in Madhav Rao Jivaji is applicable in cases where the court finds that the dispute involved therein is predominantly civil in nature, and the parties should be given a chance to reach a compromise. Example, matrimonial, property, and family disputes. Pausing here for a moment, and this is the only part I'll read of 22. But then the question arises, in the facts which I've shown from the FIRs, complaints, and the charge sheet, whether your lordships will feel that it is at all one of the cases where the parties can be given an opportunity to settle the matter. It is a matter where one party is trying to grab possession of a property from another person. It is not merely a civil dispute, which, like it was in Madhav Rao Jivaji, only related to tenancy. There's physical force applied on 2-3 occasions. There's injuries. There's also death of another person, though I'll at the cost of only repetition. Though the murder is not, the allegation of murder is not on the writ petitioner, but out of the same incident, in a cross FIR, two persons have already died. So it is not a case where a compromise can be reached between the parties, and definitely not a case which is related to matrimonial or family dispute or a property dispute also. It is about grabbing of the property, not title of the property. The Madhav Rao Jivaji will not apply in view of this 2011-12 SCC 437. Now, the next one is 1998 7 SCC 698 Ashok Chaturvedi and others.
Yes.
My lord, here your lordships will find, kindly my lord takes page 70, if it's a true copy, my lord, page 701, or if not, my lord, then
Paragraph numbers is
paragraph 7, it's a long 5 longish paragraph.
Yes.
But kindly takes
701.
yes, 701, kindly takes, my lord, just after placetum B, between placetum B and C. The petition of complaint is vague one.
Yes.
And accepting the bold allegations that the shares of the complainant had been transferred on forged signature, nothing further has been stated, and there is not an iota of material to indicate how all or any of these appellants are involved in this so-called alleged forgery. Now, I have read out the complaint, my lord. There are specific allegations against the writ petitioner, and it is not one of those cases where there are vague and bold allegations only glossing over that Parag Majmudar is involved. And my lord, this judgment is the factual difference. Other thing is, my lord, kindly takes paragraph 5 top now. The question which actually fell for consideration in this case was that 5 top. But the question that yet remains for consideration is whether the allegations made in the petition of complaint together with the statements made by the complainant and the witnesses before the magistrate taken on their face value do make the offences for which the magistrate has taken cognizance of. Therefore, my lord, it turns on those facts. The court was only considering whether in that complaint, that materials, whether the accused name features or not. Therefore, my lord, factually, my lord, it will not apply in our case. My lord, also similar is Bhaskar Chattaraj 1991 supplementary 2 SCC 574. Here also, my lord, your lordships will find that the consideration was mostly on facts. It's a very short judgment of 2 paragraphs, 3 paragraphs. My lord, kindly takes paragraph 3, my lord, where my lord, in the page 575. This is 1991 supplementary 2 SCC 574.
এই জাজমেন্ট গুলোকে একটু ভালো করে আলাদা করে রাখবে। Yes.
Yes, my lord, here the petitioner relied on paragraph 3. My lord will kindly take the second page of that printout, 575, which is the page 575. Kindly take the bottom 4 lines. The learned counsel appearing on behalf of the respondent is not able to satisfy us showing any material that would justify the implication of the appellant with the offense for which he now stands charged. So, my lord, I can only hope that the counsel for the respondent here has done a better job before your lordship, my lord. Well, your lordship will find thereafter the lack of those materials persuaded the court to hold that there are not enough materials against the accused.
All right.
Malad, then Malad 2024 4 SCC 289.
Yes.
May I hand over a copy, Malad? 24 Shiv Jatia.
What happens with 2 copies, my noting gets
Minor.
here and there, and it becomes very difficult to prepare the judgment. This is the reason I want things to be kept in one place. 2024
4 SCC 289.
8 SCC I get Probir Purokayasto. Achina. Yes.
Well, the petitioner has relied on paragraph 23 to 27.
All right.
Now, my lord, in this judgment, my lord, in the facts of that case, my lord, there was enormous delay, my lord, in the criminal proceeding. My lord, kindly take, my lord, paragraph 19 and 20. And then 26, 19, 20 and 26.
Yes.
It is not the case of the first respondent complaining that when the learned magistrate passed the order dated 16 July 2013, there was some additional material on record. At least the order of the learned magistrate does not say so. The order does not even consider the earlier order of 15 December 2011, calling for a report under subsection 1 of section 202 CRPC. The order issuing process has drastic consequences. Such orders require the application of mind. Such orders cannot be passed casually. Therefore, in our view, the learned magistrate was not justified in passing the order to issue the summons. Therefore, an order of remand is warranted. But we cannot overlook that the complaint's subject matter of these appeals was filed on 17 July 2004 and the order of summoning was passed 9 years thereafter, that is on 13th of August 2013. The complaint is nearly 20 years old. Even the summoning order was passed 11 years ago. Therefore, we allowed the learned senior counsel appearing for the parties to address us on merit. We may note that the High Court has not recorded cogent reasons for not entertaining the prayer for quashing the complaint. The only reason given by the High Court is that there were disputed questions of fact and therefore the controversy can be decided only after evidence is recorded. We have perused the averments made in the complaint and examined the documents relied upon by the first respondent complainant. The first document is the distributorship agreement dated 22nd September 2002, executed by the accused company in favor of the second respondent, Arun Sharma, in his capacity as the proprietor of Arcia Max Bank. Under the said agreement, the accused company appointed the second respondent as the exclusive distributor, confined to the territory specified in Annexure 1 to the agreement. The territory was limited to Panchkula and Chandigarh. Clause 1 of the agreement clearly states that the second respondent accepted the appointment as an exclusive distributor of the accused company in the territory as defined under Annexure A. Taking the said agreement as correct, there is no clause in the agreement which allows the second respondent to appoint anyone as sales outlet point of sales on behalf of the accused company. So, the agreement has been looked into. Then, kindly take paragraph 26. Other paragraphs are also on the distributorship agreement, but 26 will give you a snapshot of what the Supreme Court was considering. In fact, the entire dispute is of civil nature arising out of a commercial transaction. Therefore, in our considered view, taking the complaint and documents relied upon by the first respondent complainant as correct, no case was made in the complaint or in the evidence of the first respondent to proceed against the appellant. The evidence of CW3 shows that he has stated that the second, fifth, and sixth respondent in the criminal appeal of the accused number 2 had approached the first respondent complainant and has represented that the accused company is a limited company and accused number 2 and 4 are his directors. There is no allegation that the accused company was involved in any manner with the transaction between the second accused and the first respondent complainant. Hence, continuing the complaint against the appellant will amount to abuse of the process of law. Therefore, a case is made out for quashing the complaint as regards the appellant. So, Malad, this is also, Malad, your Lordship will find, Malad, quite different from the facts, Malad, before your Lordship. And, Malad, your Lordship will kindly note that this was a matter under section 482. Therefore, my lord, even after the trial, when the statements were recorded, and sorry, my lord, the deposition was recorded, the court had looked into those statements. Now, my lord, I had shown one judgment. I have got a better judgment today, my lord. I should have shown that one only, my lord. I have shown 2025 STC Online SC 1948 that once the cognizance is taken, my lord, your lordships will not interfere under 226. That is, Malad, valid for Shakespeare Sharoni PS case number 314 and 340. But on that, Malad, I have got a better judgment, which is referred there. Malad, I should have brought that only. But this is 2024 SCC Online SC 5761. But this was referred in the other judgment, which I had placed. Kindly take paragraphs 3 to 7 and 9. We have no doubt in our mind about the contours of jurisdiction of the High Court when a challenge is presented asserting that the impugned FIR ought to be quashed on the settled parameters. However, sight cannot be lost of the settled legal position that it is entirely within the discretion of the High Court whether to interfere or not when other remedies are available. If during the pendency of the writ petition under Article 226 of the Constitution before a High Court where an FIR is challenged, the investigation is completed and the charge sheet filed, in pursuance whereof the competent criminal court takes cognizance of the offence, the court would be disabled in proceeding with the writ petition owing to a judicial order having intervened. We can profitably refer to the decision of the bench of 3 judges of this court made on reference in Radhesham versus Chabinath. While disapproving the view expressed in Surya Devi Rai versus so-and-so, it was held that judicial orders of the civil court are not amenable to writ jurisdiction under 226 of the Constitution, and the jurisdiction under 227 is distinct from jurisdiction under 226. We may also note that from the decision that upon considering the decisions of high authority, a principle of law was laid down that challenge to judicial orders could lie by way of an appeal or a revision or under 227 of the Constitution, and not by way of a writ under 226 and 32. The underlying reason why judicial orders are not amenable to challenge in the writ petition under 226 of the Constitution seems to be that such orders cannot be legitimately claimed to have been passed by the presiding officer of a court in breach or violation of fundamental right or any right conferred by the Constitution or a statutorily conferred right, which could be corrected by issuance of a writ of certiorari in exercise of high prerogative writ jurisdiction of the High Courts. After all, should any right of a person be infringed as a consequence of judicial orders, the law provides for the fora where such order is amenable to challenge, and it is for such fora which ought to be approached for redress of one's grievance. This position flows from the Constitution bench decision of this court in Naresh Sridhar Mirajkar and Rupa Ashok Hura, as well as decision of the bench of 3 judges in Sadhana Lodh versus National Insurance Company Limited. Although Radhesham dealt with judicial orders passed by civil courts, there cannot be a different standard for judicial orders passed by criminal courts. If a judicial order passed by a civil court cannot be challenged in a writ petition under 226 of the Constitution, a fortiori a judicial order passed by a criminal court cannot also be challenged in a writ petition under 226. Mr. Nagamuthu, in the usual failure, rightly did not dispute that judicial order is not amenable to challenge in a writ petition under Article 226. Since the remedy under 226 is discretionary, the impugned judgment and order cannot also be faulted on the ground that the discretion was arbitrarily exercised. Besides, dismissal of the writ petition as infructuous did not foreclose the rights of the petitioners to seek relief elsewhere according to law. Then Malad takes paragraph 19. We therefore hold that the High Court was absolutely right in dismissing the writ petition as infructuous, noticing that a judicial order had intervened between presentation of the writ petition and consideration thereof. No substantial question of law is involved, and hence the appeal is also dismissed. Therefore, the challenge as far as 314 and 340 is concerned needs to be dismissed as infructuous, not to be considered on merit, because the trial in those 2 cases are going on. As far as Anandapur PS case number 188 and 397, those should be judged, ought to be judged on the parameters of quashing. Now, in the parameters of quashing, Bhajanlal principles, etc., whether case is made out or not, that part I have covered by placing the complaint and the charge sheet. What remains to be shown, and I'll just come to that, after one judgment, that in application of the discretion, what your lordships will not look into. Because this is not a trial, at the cost of repetition, I'm making this submission. But before that, I'll just, on this same point, I'll show one more judgment, that is 2025 SCC Online SC 938. This is, George Shop copy 2025 SCC Online SC 983. paragraph 30 and 45. Malad 30 is basically Malad a quotation from Niharika Infrastructure of 2021, which says that Malad that when your losses will not interfere also. But Malad, in place of placing Niharika, Malad, I thought it fit to place a recent judgment, Malad, where Niharika has been considered. But kindly take paragraph 30. I'll just place a few sub-paragraphs of Niharika Infrastructure, Malad. Malad, may I place it, Malad? 33.2, kindly take 33.2 within the quotation. The courts would not thwart an investigation into a cognizable offense. Then 33.4. The power of quashing should be exercised sparingly with circumspection, as it has been observed in the rarest of rare cases, not to be confused with the formation in the context of death penalty. Then 33.5. While examining an FIR or complaint, quashing of which is sought, the court cannot embark upon an inquiry as to the reliability or genuineness or otherwise of the allegations made in the FIR or complaint. Then 33.6. Criminal proceedings ought not to be scuttled at the initial stage. Then 33.7. Quashing of a complaint on FIR should be as an exception rather than an ordinary rule. 33.8. Ordinarily, the courts are barred from usurping the jurisdiction of the police, since the two organs of the state operate in two specific spheres of activity, and one ought not to tread over the other sphere. Then 33.9. The functions of the judiciary and the police are complementary, not overlapping. Then 33.12. The first information report is not an encyclopedia, which must disclose all the facts and details relating to the offense reported. Therefore, when the investigation by the police is in progress, the court should not go into the merits of the allegations in the FIR. Police must be permitted to complete the investigation. It would be premature to pronounce the conclusion based on hazy facts that the complaint or the FIR does not deserve to be investigated, or that it amounts to a process of abuse of the process of law. After investigation, if the investigating officer finds that there is no substance in the application made by the complainant, the investigating officer may file an appropriate report summary before the learned magistrate, which may be considered by the learned magistrate in accordance with the known proceeding. Now, my lord, kindly comes to paragraph 45. This is extremely, my lord, essential in our case, 45. Last page, my lord. Even though the above decision was rendered in respect of trial of cross cases, this court is of the opinion that in cases involving cross FIRs, it would be prudent and fair if the investigation was carried out in a comprehensive manner. After all, the object of the investigation is the discovery of truth. In the present case, in view of cross FIRs, the investigating authority will conclude that either the receipts in favor of the appellant are forged and fabricated, or that the receipts are genuine. The complicity of the respondent number 2 and 3 herein can only be ascertained once the investigation is permitted to reach its logical conclusion. Though the investigation here is complete, what I want to highlight is that this is also a case where FIR number 397 is before lordship, but FIR number 398 is also there, which is originating out of the same incident.
But is there any cross FIR?
So it is not, the accused in one is the complainant in the other, or the complainant in one is the accused in other. But the incident, the 397 is the first part of the incident where the lurking house trespass took place, and as a fallout of that incident, that action, the reaction was shooting with the gun of Ratan Lal Nahata. Therefore, what is important is the comprehensive trial, because the investigation stage is today complete. What is, if it is thwarted today, kindly sees, for an example, if your lordship are persuaded by the arguments of the petitioner, 397 is quashed, but 398 will survive because that is not before lordship. So the action is not tested. By calling it, it will end up as an abuse of the process of law, or it is so unthinkable that it will end up in harassing the petitioner. But 398, which is actually a fallout, because this accused in the other matter, Mamta Agarwal, did not suddenly take a gun of Ratan Lal Nahata and shoot two people of his own staff. Some people entered, that is undoubtedly established from the investigation. Therefore, I read this paragraph, since there is not really a cross FIR, but FIRs dependent on each other, this has to be allowed to, the trial should be allowed to be completed. Now, as I was submitting, the propositions on the quashing, 2009 volume 1. What your lordship will not look into while considering a petition for quashing. This is 2000 Act. 2009 volume 1 SCC 500. Paragraphs 15 and 16. And Malad, 15 subparagraph 4 will also cover one of the major points in the application CAN 4. 15.1. The High Court ordinarily would not exercise its inherent jurisdiction to quash a criminal proceeding, and in particular, a first information report, unless the allegations contained therein, even given face value and taken to be correct in their entirety, disclose no cognizable offence. For the said purpose, the court, save and except in very exceptional circumstances, would not look to any document relied upon by the defense. But your lordship will find in CAN 4, I'll place a few paragraphs. Your lordship will find that they have introduced some documents in CAN 4, besieging in the prayer of that application for your lordships to look into it. That is why, my lord, subparagraph 2 is important, my lord. Here, your lordship's object is not to look into the documents of the defense.
Those documents are not there before the trial court.
My lord, I have not cross-checked, my lord. I'll be very honest, my lord. But, my lord, the purpose is to, my lord, persuade your lordship that no case is made out against them. But this is not the forum where your lordship will look into those documents, my lord. Unless your lordship hold that these are very exceptional circumstances that justice cannot be rendered without looking into that document. Subparagraph 3. Such a power should be exercised very sparingly. If the allegations made in the FIR disclose commission of an offence, the court shall not go beyond the same and pass an order in favor of the accused to hold absence of any mens rea or actus reus. Therefore, your lordship will also not look into whether the accused has mens rea or not. 4. If the allegation discloses a civil dispute, the same by itself may not be a ground to hold that the criminal proceeding should not be allowed to continue. Therefore, merely because some aspects of civil dispute is there, that is not a ground to quash the criminal proceeding by itself. Then 16. It is furthermore well known that no hard and fast rule can be laid down. Each case has to be considered on its own merit. The court, while exercising its inherent jurisdiction, although would not interfere with a genuine complaint, keeping in view the purport and object for which the provisions of 482 and 483 of the code had been introduced by Parliament, but would not hesitate to exercise its jurisdiction in appropriate cases. One of the paramount duties of the superior court is to see that a person who is apparently innocent is not subject to persecution and humiliation on the basis of a false and wholly untenable complaint. Now, my lord, your lordships will kindly take, but before showing, my lord, taking your lordship to the next and the last batch of, my lord, judgments, my lord, which I am to show. My lord, kindly, my lord, takes one factual aspect. Thereafter, I'll show some pleadings, my lord. My lord, in this matter, my lord, there was a intervening Supreme Court order, my lord, which your lordships will find in CAN 4. Kindly takes, my lord, CAN 4, page 49.
Page 49
of CAN 4.
All right.
এরপরে এটাও একটু বার করে দেবে না, দেখে নিন একবার, এটা অপোজিশন আছে।
Yes, Supreme Court's order.
এখন বসুন।
Yes.
My lord, kindly seize, my lord, this order. The parties are before this court pursuant to a civil litigation since 2002. During the past 16 years, there have been several litigations, and we find that 5 criminal cases are pending between the parties. When the matter came up before this court, after noticing that there is an element of settlement, we sought the assistance of Varuna Bhandari, learned counsel, and also a trained mediator. We are informed that the learned mediator has put in 35 hours in the mediation thanks to strenuous efforts thus taken by the learned mediator. We are happy to note that the parties have settled their entire disputes, and they have filed the application for directions along with the deed of settlement dated 16 July, duly signed by all the parties and the learned mediator in the registry of this court. In view of the deed of settlement dated 16 July 2018 referred to above, We are of the view that the securing ends of justice, the criminal cases involving them should also be closed. Accordingly, Lake PS case number 23 of 2008, 2255 of 2012, Lake PS case 56 of 2009, 4342 of 2008, and Shakespeare Shawnee PS case number 314, 340, and 397 are also quashed. Now, my lord, this appeal, this civil appeal, my lord, went up from a civil suit which was before this court. Definitely, my lord, state was not a party in this SLP. It is civil appeal. My lord, this order was placed before the learned trial court. Therefore, the trial court discharged all the accused, which is also there in the list of days which I have provided regarding the delay, my lord. My lord, when state came to know about this order having been passed, my lord, state made of the facts and also recalling of that part of the order. Well, that your lordship will find if your lordship takes an affidavit in opposition that the state has filed in Can 4, but it is titled Affidavit in Opposition of the writ petition as well as Can 4 in respect of Shakespeare Shawnee PS case number 314 of 2013. It is in the heading 314 is mentioned. It, February 2025. $314 will be written in the headings. আমারটাই দিয়ে দিয়েছি আমি হেডলাইনটাই দিয়ে দিয়েছি
এর মধ্যে তো শুধু সাপ্লিমেন্টারি এফিডেভিটটা আছে, অর্ডার শিটস আছে। Did you file
25, Mala, 25.
25?
But this was filed prior.
This one?
Then supplementary affidavit later, Mala. This is the main opposition to the writ petition.
দেখুন তাহলে
53-68 দেখুন 53-68 এটা না পাল্টান এটা না Malad, kindly takes Malad the order passed in my application, page 17.
Yes.
The application filed by the state is taken on record. It is prayed for in the application that the following cases have nothing to do with the settlement of disputes in issue. Therefore, the following 4 cases appearing in paragraph 4 of the order dated 17 July 2018 are deleted. Shakespeare Shawnee PS 14, 340, 397. Consequently, all the above 3 cases are directed to be proceeded with in accordance with law. Since they are not otherwise settled, the orders passed by the trial court discharging the accused in the above 3 cases will stand recalled. The cases will proceed from the stage they were pending before the trial court at the relevant time. Then so and so, Malad. Then other part is not important, Malad. Therefore, Malad, all the cases were again restored, and the trial, Malad, as far as where the trial was proceeded, and where adjournments were proceeded. Now, Malad, while your lordship is at Can 4, Malad kindly takes a few pleadings.
Yes.
Malad kindly takes page 18, page 17. Page 17, paragraph 13. But in just briefly, Malad, I'm showing Malad what are his grounds, Malad. That to appreciate the Shakespeare Shawnee PS case number 340, dated so-and-so, which was initially initiated under section so-and-so and later amended to so-and-so, read with so-and-so of the Arms Act, the petitioner begs to state as follows, that while he was in custody in connection with Shakespeare Shawnee PS case number 397 under section so-and-so, he came to know that he has also been tagged in two similar criminal cases, being Shakespeare Shawnee PS case number 314 and 340. Malad, I have shown that in those two complaints also specifically he was named in the complaints. So it is not a case, Malad, where he was first arrested 397 and then tagged in the prior two cases. The cases were already registered against him in those cases. Then Malad kindly comes to Malad. Yes, but paragraph 27, page 27, paragraph 22, Roman 2. That it appears from the body of the complaint that the dispute is purely civil in nature, which has been given a criminal color. It was totally a business transaction between the companies. The complainant was never induced to appear. As it appears from the body of the complaint, there is not an iota of entrustment or retention personally by the present petitioner. This he is saying with regard to HON'BLE PS case number 188. But there also, I have read out the 5-6 pages complaint, where the complainant specifically says that I was induced by Parag Majmudar and two other persons named were there. Number one. Number two, the judgment, which I have shown R. Kalyani, 2009, volume 1, it specifically says that merely because civil disputes are there, it is not a sole ground to quash a criminal complaint or a criminal proceeding. There must be other attending circumstances that a person is being pinpointedly targeted, that to harass him and to embroil him into criminal proceedings. Now, the conduct of the petitioner, luckily, he has challenged 4 FIRs together. The entire picture before Lordship, that he is not someone who is having a very clean slate. Next, your Lordship will kindly take what I was trying to point out at that time. He has introduced two documents. Your Lordship will find page 29. One in paragraph Roman 6, yes, one surrender slip, and one in paragraph Roman 7, which is the director's details of the complainant, that he says that during the time of occurrence of the alleged offense, the complainant himself was working as a director in all the companies. Then he has given a director's slip and so and so. So these documents, your Lordship, in terms of the Supreme Court order, will kindly not look into these documents of the defense in this jurisdiction. Now, kindly takes, the writ petition ones. That is 5368.
Yes.
Kindly takes paragraph 27.
Yes. Affidavit.
No, the writ petition. Main writ petition 5368. Paragraph 27. Paragraph 27, page 20. And this is perhaps the only specific pleading for quashing of the FIR, the criminal proceeding. My learned senior will correct me if I'm wrong. Obviously, not a single charge will stick. However, that is not the intention of the respondent number 5, Mr. Boidyanath Saha, and his associates. The real intention is to drag the case as long as the judicial process allows, so that it is actually becomes the punishment by trial. The judicial system will ultimately notice the utter silliness of the arguments of the prosecution and submissions, but your petitioner will suffer mental, physical, emotional, and economical agony of appearing on dates months after months, which must not be allowed. Therefore, my lord, his point is delay in trial. As far as 314 and 340 is concerned, trial is already proceeding. As far as 397 is concerned, I have shown, my lord, at least 37 adjournments till 2025 has been taken by the petitioner himself. Now, my lord, on the point of delay in trial, my lord, kindly take, my lord, a few judgments, my lord. 1992, volume 1. Well, 1992, volume 1 SCC, 225, paragraphs 83 to 86.
Paragraphs 82 to
83 to 86.
83 to 86. Yes.
Well, kindly takes 83 first, page 268, at page 268. But then, speedy trial or other expressions conveying the said concept are necessarily relative in nature. One may ask, speedy means how speedy? How long a delay is too long? We do not think it is possible to lay down any time schedules for conclusion of criminal proceedings. The nature of offense, the number of accused, the number of witnesses, the workload in a particular court, means of communication, and several other circumstances have to be kept in mind. Then, Madam, kindly takes just above Placetum G. A murder case. A murder case may be a simple one involving, say, a dozen witnesses which can be concluded in a week, while another case may involve a large number of witnesses and may take several weeks. Some offences by their very nature, example, conspiracy cases. But in our FIR, one of the conspiracy is there. Conspiracy cases, cases of misappropriation, it is there. Embezzlement, fraud, forgery, sedition, acquisition of disproportionate assets by public servants, cases of corruption against high public servants and high public officials will take longer time for investigation and trial. Then again, the workload in each court, district, region, and state varies. This fact is too well known to merit illustration at our hands. In many places, requisite number of courts are not available. In some places, frequent strikes by members of the bar interferes with the work schedules. In short, it is not possible in very nature of things and present day circumstances to draw a time limit beyond which a criminal proceeding will not be allowed to go. Even in the USA, the Supreme Court has refused to draw such a line. Except for the Patna full bench decision under appeal, no other decision of any high court in this country taking such a view has been brought to our notice, not to our knowledge in United Kingdom. Wherever a complaint of infringement of right to speedy trial is made, the court has to consider all the circumstances of the case, including those mentioned above, and arrive at a decision whether in fact the proceedings have been pending for an unjustifiably long period. In many cases, the accused may himself be responsible for the delay. In such cases, he cannot be allowed to take advantage of his own wrong. In some cases, delays may occur for which neither the prosecution nor the accused can be blamed by the system, but the system itself. Such delays too cannot be treated as unjustifiable, broadly speaking. Of course, it is then Alice gives one sentence after question G. D. Each case must be left to be decided on its own facts, having regard to the principles enunciated hereinafter. For all the above reasons, we are of the opinion that it is neither advisable nor feasible to draw or prescribe an outer limit for conclusion of criminal proceedings. It is not necessary to do so for effectuating the right of speedy trial. We are also not satisfied that without such an outer limit, the right becomes illusory. We may next deal with what is called the demand rule. The contention is that an accused who does not demand speedy trial, who stands by and acquiesces in delay, cannot suddenly turn around after a lapse of a period and complain of infringement of his right to speedy trial. It is not possible to accede to this contention either. An accused does not prosecute himself. The state or complainant prosecutes him. It is thus the obligation of the state or the complainant, as the case may be, to proceed with the case with reasonable promptitude. Then just above placetum H. Of course, in a given case, if an accused demands speedy trial and yet he is not given one, may be a relevant factor in his favor. But we cannot disentitle an accused from complaining of infringement of his right to speedy trial on the ground that he did not ask for or insist upon a speedy trial. Then 85. Another question seriously canvassed before us related to consequence flowing from an infringement of right to speedy trial. Counsel for the accused argues that on the basis of the observations in Sila Barshe and Strang, that the only consequence is quashing of charges and or conviction as the case may be. Pausing here for a moment, the court is considering that when the court is not minded to quash the proceeding, then what is to be done? Normally, it may be so, but we do not think that that is the only order open to the court. In a given case, the facts, including the nature of offence, may be such that quashing of charges may not be in the interest of justice. After all, every offence, most economic offences, those relating to public officials, food adulteration is an offence against the society. It is really the society, the state, that prosecutes the offender. We may, in this connection, recall the observations of this court in Champalal Sunjaji Shah. In cases where quashing of charges or conviction may not be in the interest of justice, it shall be open to the court to pass such appropriate orders as may be deemed just in the circumstances of the case. Such orders may, for example, take the shape of orders of expedition of trial and its conclusion with a particular prescribed period, reduction of sentence when the matter comes up after conclusion of trial and conviction, and so on. In view of the above discussions, the following propositions emerge, meant to serve as guidelines. We must forewarn that these propositions are not exhaustive. It is difficult to foresee all the situations, nor is it possible to lay down any hard and fast rules. Since I have read out the analysis before that, I'm not reading the sub-paragraphs, but kindly deem it to be placed by me. Because ultimately, those are carved out in a synopsis form in paragraph 86. But I'm relying on 86. Next, your lordship will kindly take division bench of Bombay High Court, where also the delay was considered. This is 2023 SCC Online Bombay 1727. Paragraph 48, 49, 51 to 55.
Yes.
Kindly text 48. For 254.
Yes.
For the reasons aforestated, we find that this is not a case wherein it could be said that even upon taking all the allegations made against the petitioner on their face value, and by accepting them as they are, no prima facie case is made out against the petitioner in respect of the charge which has been framed against them, and that would mean that it is not a fit case for quashing and setting aside of the criminal proceeding. The conclusion reached above receives further support from the nature of the allegations made against the petitioner and the remaining accused persons in the present case. These allegations show that the transactions in question were not predominantly and overwhelmingly of civil flavor and has greater repercussions on the economic system of India, and prima facie they could not be regarded as one-off transactions. Rather, they being related to a greater conspiracy to cause monetary loss to banks, financial institutions, and investors in India. A possibility of their having criminal flavor in true sense cannot be ruled out at this stage. Then 51. Of course, there is also an argument that the criminal trial has not proceeded any further after framing of charge in the year 2007, and this has caused great prejudice to the defense of the petitioner, while quashing of the criminal proceedings would cause no prejudice to the prosecution. While placing reliance upon the case of P. Ramchandra Rao, it is contended that because of the unreasonable delay in completion of the trial, right of the accused to speedy trial has been infringed. We, however, do not accept the contention and reject it for the reasons which follows this paragraph. As rightly submitted by the learned counsel for the respondent number 1 CBI, the concept of speedy trial has been well explained by the Constitution Bench of the Supreme Court in A.R. Antule versus R.S. Nayak, wherein the Supreme Court has held that the concept is necessarily relative in nature. It further held that neither advisable nor practicable to fix any timeline for trial of offences, and much would depend upon the several factors such as nature of the offence, number of the accused, number of witnesses, workload in the particular case, means of communication, and several other relevant circumstances. It also held that each and every delay does not necessarily prejudice the accused, as some delays indeed work to his advantage. Probably that is the reason 37 adjournments have been taken. Similarly, in Kartar Singh versus State of Punjab, after Constitution Bench of the Supreme Court found that no length of time per se is too long to clear the test of speedy trial principle, not the accused is under a duty to show the actual prejudice by the delay of the disposal of the case. It also held that in such a case, the court has to adopt a balancing approach by taking note of the possible prejudices and disadvantages may be suffered by the accused by avoidable delay, and thus has to determine whether there is really any deprivation of the accused of the right to speedy trial or not. The relevant observations are reproduced as under. Now I am skipping the quotation. The aforesaid proposition of law was reiterated in P. Ramachandra Rao, which was a 7-judge bench decision, which, with the clarification that the guidelines laid down in A. R. Antule are not exhaustive but only illustrative, and that they are not intended to operate as a hard and fast rules to be applied like a straitjacket formula. It further held that their applicability would depend on the fact situation of each case. Having regard to the aforesaid principles of law, we find that this is not a case which could be quashed only upon consideration of what apparently seems to be a long delay in conclusion of trial. As stated earlier, this case involves transactions which are alleged to be part of larger conspiracy of defrauding Indian investors and which indicate element of fiscal impurity. Then there is presently only one special court which is now dealing with all these cases, some of which have voluminous evidences. This is also an interim relief staying. There is also an interim relief staying all proceedings are so and so. All these circumstances would only show that there is no deliberate delay by the prosecution. Rather, the delay seems to be systematic, but it is a question of to be decided by this court as to whether or not any delay of systematic nature would inure to the benefit of the accused. The answer would have to be given in the context of the factor of prejudice to the accused. If there is any prejudice occurred to the accused, the advantage must go to the accused. If not, the benefit would be withheld. In this case, there does not appear to be possibility of causing any prejudice to the petitioner, as the evidence to be adduced by the prosecution is predominantly documentary and not oral. Therefore, if there is any delay, it is more likely to cause prejudice to the prosecution and can possibly even work to the advantage of the petitioner. Therefore, we find that on the anvil of the principle laid down in P. Ramachandra Rao, this is not a case of clear infringement of the right of speedy trial of the petitioners, and therefore no advantage of this principle can be granted to the petitioner. Now, my lord, here I will just add one factual aspect, my lord. Your lordship must have already noticed by the nature of prayers in the writ petition that the petitioner is on bail. The petitioner is not, my lord, behind the bars. Therefore, my lord, even in the earlier judgment, my lord, that line that your lordships can remedy the delay in trial by reducing his sentence also does not apply. So, my lord, he is at large. It is not that because of the delay in trial, he is languishing in the prison for 13 years. It is not that case. And my lord, again, my lord, my learned senior will correct me. Apart from loss of reputation as a businessman and as a engineer, my lord, he is one qualified engineer. Apart from that loss in reputation, my lord, no other prejudice has been disclosed, my lord, as far as what I have read in the CAN 4 and the 2 writ petition pleadings. Now, my lord, the last one, my lord, 2004 volume 13 SCC 671. Paragraph, actually effectively one paragraph is there, but paragraph 2. This appeal has been filed challenging the order dated so and so passed by the Calcutta High Court in CRR so and so, whereby the proceeding in special case number 4 under section 420 and 468 of the Penal Code and 5 subsection 2 and 5(1) of the Prevention of Corruption Act against the accused respondent was quashed on the ground of inordinate delay in concluding the trial. It appears that the prosecution was launched in that case in the year 1975, and after cognizance was taken, the accused moved the Calcutta High Court by filing a revision for quashing of the proceeding, which was disposed of in the year 1990 with a direction to the special court to conclude the trial within a period of 6 months. Since the trial could not be concluded within 6 months, the accused unsuccessfully made a second attempt before the High Court for quashing the proceedings, and this time a direction was given to conclude the trial within 3 months by an order dated 26 October 95. Therefore, thereafter the prosecution evidence was closed. The accused entered the defense. The special court heard arguments of both the sides, and the case was reserved for judgment. When the case was pending judgment on 19th August 1996, an application was filed on behalf of the accused. Third application, this is third application, under section 311 of the Code of Criminal Procedure for examining certain persons as defense witness, which prayer was granted by the trial court. Even after having obtained an order in his favor under section 311 of the Code of Criminal Procedure, the accused, instead of examining the defense witnesses, adopted dilatory tactics by moving the Calcutta High Court for quashing of the proceedings on the ground of inordinate delay in trial. The High Court, instead of dismissing the application, allowed the same and caused the prosecution, whereby premium has been granted to the accused, who was the wrongdoer, as the trial could not be concluded on account of the fact that he repeatedly moved the Calcutta High Court for quashing of the proceedings and got the same stage every time, although at the stage of filing his final hearing he lost. This being the position, we are clearly of the view that the High Court was not at all justified in quashing the proceedings. Well, here also your Lordship will kindly consider that it was the petitioner and the persons related to the petitioner in the civil suit who went up in appeal misled the Honorable Supreme Court, where state was not a party, to quash criminal proceedings which are not part of the settlement procedure at all. It is quite clear from the recalling order of the Honorable Supreme Court. And there is no opposition in that application. Lordship will not find that they have made an argument or elaborate argument saying that no, they were part of the settlement agreement and the state is wrong in saying that. Our application virtually went unopposed before the Honorable Supreme Court, because the fact remains that these cases have nothing to do with the settlement agreement which they read before the Honorable Supreme Court. By virtue of that order, without pointing out before the Supreme Court that these cases have nothing to do with the settlement agreement, they placed this order before the trial court. They got themselves discharged in that proceeding. Then when the state went up, state obtained an order, then came back, and then again the trial got back on track. It is maybe not 4 applications like in this case, but the question is whether it was because of at the behest of the petitioner that there was stalling of the criminal proceeding before the trial court or not. If it is so, then no leverage should be given by your Lordship to the accused before your Lordship. Now, those are primarily my points, therefore, on the face of the allegations which are against the petitioner, because of the conduct of the petitioner, and it is not an isolated case, where his name has featured in the complaint, it is quite clear, from the reading of the 3 complaints that the petitioner was in the process of grabbing the property by force, which has come out in my investigation as well, we have filed an elaborate charge sheet, we have given the documents, we have given a list of witnesses. It is a case where numerous witnesses, in some cases at least, numerous witnesses are there, which should normally take time, in conclusion of the trial. What struck my attention, while taking out this judgment, that this A.R. HON'BLE, this judgment was rendered in 1992, and we are in 2026, even after 34 years, our situation has remained the same, and the problems discussed there in paragraph 83 still remains after 24 years.
That is the reason this judgment is so very important.
Important, and it is our fault also. We have not been able to change the situation. The problems being the same, which your Lordship can always take judicial notice of, and in fact, I have given the exact reasons, that for various resolutions of the bar also, which are beyond the control of the accused and the prosecution also, the trial got the taking of cognizance of that offence, it got delayed. So, your Lordship will kindly allow the trial to go on. If your Lordship deem it fit that the trial has taken a longer time, as discussed in this judgment in A.R. HON'BLE, the alternative is to set a timeline or a guiding timeline that within which the trial should at least commence, and no unnecessary adjournment is given neither to me nor to the accused. Your Lordship will find in the list of days, there are 13 accused in that matter. All the 13 accused, since they are on bail, they cannot be collected together and produced before the court. And every day, either 8 persons are present, 5 is not present, 9 is present, 4 is not present, either Ram is present or Sham is present. And since none of them are present together, the matter cannot be proceeded with. But this much liberty should not be given by the trial court also, and those trials which are already continuing, the Lordship may direct them to be concluded at appropriate time, Though, my lord, the judgment says that no straitjacket formula or no particular timeline can be laid down, but my lord, the guidance, my lord, from your lordship, my lord, will help the trial court in not at least granting unnecessary adjournments. And my lord, the trial therefore can go ahead. My lord. My lord, those are my submissions.
When will the reply be given? Next week?
My lord, on behalf of the applicant, yes,
Something,
on
right,
behalf of the applicant,
right.
next week, my lord.
But then state will be supporting you, isn't it?
Yes, some points are there which needs to be addressed before your lordship. There are some
From
points.
your end.
Yes, your lordship.
You are the complainant.
Yes, your lordship.
All right, then I'll hear you on the next day. A reply comes later on. Learned counsel for the state concludes argument.
Applicants.
The
No, no. Next date.
what is the name of your client? The applicant?
Shafiq Ahmed.
Shafiq Ahmed.
The complainant in 397.
Comma the complainant
And
in
Mamta Agarwal.
Yes,
And Mamta Agarwal.
Expression case number 397. We'll make submission on the next date, 13th March, 2 p.m. Please prepare your written notes of arguments with the judgments. Do not hand over copies and the highlights of the judgments so that it becomes easy for delivering of the judgment and it doesn't stay over here, this side, for long.
Will it be a lordship desire that I give the quotation of which I stressed on the...
Not the quotations, paragraph numbers will be suffice. Judgments গুলোকে বার করে Fixed matter 315. Yes, call.